calling you that, Mr. Parker.
Yeah.
I keep.
I get that.
I'm so used to calling you by your first name. So
Well,
like,
I think not a lot of guys named Ashley, so.
yeah. All right. Good morning, sir. Can you tell me your name?
Michael Puller.
Mr. Puller, you're here in case 2021 MM 6730 AO on a charge of battery domestic violence. Judge signing your warrant in this case has already found probable cause for your arrest. Mr. Parker, can you put your name on the record?
Ashley Parker on behalf of Mr. Pooler.
All right. Good morning, ma'am. Can you tell me your name and spell your last name?
Adria Oros, O-R-O-S.
And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the true self you got?
Yes, I do.
You put your hand down. Can you tell me how you know Mr. Pooler?
He's my fiance.
All right. And do you want to have contact with your Mr. Pooler while this case is pending?
Yes,
Has there been previous instances of domestic violence between you all in the past?
yes.
When was the most recent one prior to the incident alleged in this affidavit?
8, 7, 10 years ago.
Okay. And did drugs or alcohol play a role in this incident?
No.
State, do you have any questions for the witness?
No, Your Honor.
And Mr. Parker?
Ms. Oros, you've executed a declination of prosecution advising that you do not want the state to pursue criminal charges against Mr. Pooler.
That is correct.
You and Mr. Pooler currently reside together?
Yes, we live together.
If the court's willing, would you like for Mr. Pooler to be able to return to that residence?
Yes.
Okay, and what is that residence, the address?
652 Glengrove Lane, Orlando, 32839.
Nothing further. Thank you, Ms. Oros.
All right. And say these prior instances were from, based on your records, from when?
There was one that was in 2012 and another in 2015, Your Honor. They are both with the same victim.
All right. Does anybody want to advocate for anything other than no contact based on the facts in this affidavit and the prior history with these two individuals?
Yes, Judge, we asked the court for a $100 bond with a no hostile contact provision and a provision that allows Mr. Pooler to reside with Ms. Oros. You heard that she does want to have contact with him. She's not in fear for her safety. She's also executed a declination advising that she does not want criminal charges to be pursued by the state attorney's office. Mr. Pooler's resided in the Central Florida area for over the past 14 years. So for all those reasons, Judge, we'd ask the court to order no hostile contact. I also wanted to advise, Your Honor, Mr. Pooler, when he learned of the warrant, he did turn himself in yesterday.
All right. Mr. Parker, I want you to understand that the victim in this case may not want prosecution, but rereading this affidavit again, it seems that this was a situation captured by an independent witness on video, that their injuries, they were sustained by this victim. So I understand her desire, but how does it help me do what the law tells me I'm supposed to be doing?
No, I understand, Your Honor. I read the arrest affidavit. I haven't been able to fully investigate whether it was captured on video or speak with this independent witness. But again, Judge is taking Ms. Oros at her word that she wants contact, and again, the fact that she wants to be able to reside with him. We'd ask that they be allowed to have, again, no hostile contact.
Ms. Parker, what the Florida Rules of Criminal Procedure and Florida Statute 943.03 sorry, 943.046 and 907.041. I think based on the facts in this live in front of me, the alleged facts, the history with this defendant, his previous and prior behavior, that I can give him contact at this time. So I'm gonna do this. I'm gonna set your bond, sir, in this case, in an amount of $1,000. It's gonna come with pretrial release supervision. You have no contact with the victim in this case. You want to maintain a separate residence from this victim. I'll give you a one-time return to the residence with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You already have Mr. Parker representing you in this case. You should lean on his representations and experience in these matters. Do you have any questions about the stipulations on your no contact order, Mr. Pooler?
No, Your Honor.
All right, everybody have a great day.
Thank you, Your Honor. Have a great day.
All right, have a great day, Mr. Parker. Good morning, sir. Can you tell me your name?
Darius Washington.
Mr. Washington, you're here in case 2021 MM7411AO on charge of battery dating violence. You were seen yesterday by Judge Gibson. The state of Florida has provided supplemental information in this case, so the court does find probable cause for your arrest as to that charge. I'm going to set your bond in this case in amount of $250. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And you may not possess or consume any drugs or alcohol if you don't have without a valid prescription. You're subject to random drug and alcohol testing at your expense through pretrial release. I'm going to appoint the public defender to represent you in this matter. I think Judge Gibson did that yesterday. Right. All right. You already had a public defender representing you in this case. Do you have any questions about the stipulations in your no contact order?
No, sir.
All right. You have a great day, sir. Schiffin? All right. I'm going to appoint a public defender representing Mr. Schiffin in 2021 CF 13795AO.
I'll waive the appearance, Your Honor.
I did find probable cause for his arrest in that case, charged of battery, domestic violence by strangulation, and battery, domestic violence. Ms. Davis, if he did not, based on his history, would he qualify, or we don't have enough information?
Yes, he'll qualify.
All right. All right, going to set bond in count one in the amount of $2,000, count two $500, condition of the bond. Be subject to pretrial release supervision, no contact with the victim, maintain a separate residence from the victim, give a one-time return with law enforcement to retrieve any personal items he has at the location. May not possess any weapons or firearms. Any weapons or firearms he has needs to be turned over to law enforcement within 24 hours of his release. He may not possess any drugs or alcohol without a valid prescription. Morning, sir. Can you tell me your name?
Is there a mark?
Sir, you're here in case 2021 CF 13689AO on charges of violation of a no contact order and battery with one prior battery conviction, domestic violence. Judge signing your warrant in this case did find probable cause for your arrest. Give me 1 second. right, sir, I'm gonna set your bond in count one, amount of $5,000, count two, $500. Condition on your bond that you have no contact with the victim in this case. You're gonna maintain a separate residence from this victim, give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you may have. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case and state two questions. One, seems like you filed a no information in his other open case, correct?
Yes, Your Honor.
Two, were you going to file a motion of pretrial detention in the new case?
Not at this time, Your Honor.
Mhm. Since you're on probation, sir, so you've been held for Broward County?
No, oh yeah, there is. There is a hole.
Say again?
There is a hole.
All right. All right. So you might go deal with that in Broward County. No, I'm not putting it in part of order. He's already being detained from Broward County. On the warrant? What I miss? No weapons, no firearms, I forget. Yeah, that's all part of the no contact order. So you got any questions about the stipulation of no contact order?
No, sir.
All right, you sure you're gonna be good with this? Because
Of course, I'm just gonna
I'm just-
put stuff and leave.
I'm just saying, Judge Gibson told you, before, and it seemed not to work out. So I want to make sure you have a clear understanding about what the order says.
I have a clear understanding.
All right. All right, have a great day, sir.
So we
Thank
did
you.
take care of the no action on that.
Yeah. There's no action I can take. The case is closed.
Just making sure.
All right. Good morning, sir. Can you tell me your name?
Sir, good morning. My name is Gerard Farmer.
The farmer here in case 2021 CF 13798 AL on a charge of aggravated assault, domestic violence, arson on a dwelling, burglary of a structure, and criminal mischief. All right, and the state. Did find probable cause for your arrest as to those charges. I got questions. So state, did you have opportunity to review this charging affidavit?
Yes, Your Honor.
Did you intend to file a motion of pretrial detention in this case?
Not at this time, Your Honor.
So, Mr. Farmer, I'm going to appoint a public defender to represent you. Ms. George,
Yes, sir.
I'm going to take a look at 907.041. So sub D. So rules of criminal procedure seem to believe that a motion has to be filed. I really don't see that anywhere in the statute, but and the prior domestic violence history was with this same victim, correct?
No, Your Honor.
Is it different victims?
Yes. It goes back to 2007, but they are different victims in Orange County. I wasn't able to find, I didn't have time to look outside of the county, Your Honor.
All right. Yes. All right. My concerns. Mr. Farmer has a history of domestic violence with, looks like various victims. I did read the phase sheet, read the facts of this case, where the allegations are that he went to a ex-girlfriend's home that had broke up with him 3 weeks prior, had been stalking her, threatening her, and then seemed to have followed through with some of those threats by setting her house on fire. Put your hand down.
I'm sorry?
So my question to the state of Florida, they told me that they're not going to file a motion for pretrial detention. I'm asking Ms. George, did she had an opportunity to review 907.041 sub D, 07.041 sub D.
I did, Your Honor.
And
And if you, it looks like sub E says when a person is charged with a crime for which pretrial detention could be ordered, is arrested, the arresting agency may detain such defendant prior to the filing by the state attorney of a motion seeking pretrial release for a period not to exceed 24 hours. The pretrial detention hearing shall be held within 5 days of the state filing that, the state attorney filing of a complaint to seek pretrial detention. The state just stated they have no intentions of filing a motion for pretrial detention in this case at this time, and because of that, I would ask that you set a bond in this case.
All right.
It appears that
So what release conditions do you think are going to be sufficient to protect the victim from further physical harm and not interfere with the judicial process? What toolbox do I have, or tools I have in my toolbox that I can do that? With our current administrative orders, I don't have home detention. I don't have GPS monitoring. All I have is bonds, orders.
Your Honor, I would say if you place him on pretrial release and set a bond, from this face sheet, his only conviction was from 2007, excuse me. He's been arrested but never convicted.
All right, I mean, all right, Mr. Farmer,
Your Honor.
in this case, count one, the court's going to set your bond in the amount of $2,500. Count two, arson of a dwelling, going to set your bond in the amount of $100,000. Count three, going to set your bond in the amount of $150. And count four, $150. It's going to be all subject to pretrial release supervision. You had no contact with this victim, absolutely zero contact with this victim. You are to maintain a separate residence from this victim. Also ordered you not return to the scene of the location where this incident occurred. You may not possess any weapons, firearms, or accelerants in this case. Any weapons, firearms, or accelerants need to be turned over to law enforcement within 24 hours of your release. I already appointed the public defender to represent you in this matter. Say there's any other conditions that you think or feel are appropriate in this matter.
No, Your Honor. I believe the no contact should cover it, but sometimes you have to emphasize not within 1,000 feet of their work, their car, but I think the no contact will cover that.
Mr. Farmer, you understand the stipulation of your no contact order?
Yes, sir.
All right, you're gonna be able to abide by those stipulations.
Yes, sir.
All right, you have a great day, sir. I need to sign? No, it's fine. Yeah, we don't have an attorney appearing. I got the remote right here. All right. Good morning, sir. Can you tell me your name?
Gregory Lane.
All right. Mr. Lane, you're here in case 2021 CF 13790AO on a charge of aggravated assault, domestic violence. Judge signed your warrant. In this case, they find probable cause for your arrest.
Yeah.
Ms. Yorkshire.
Your Honor, I didn't see a warrant.
No, I said, I reviewed the
Oh.
charging affidavit.
Oh, sorry.
Sorry.
Here, Your Honor, I was reviewing this affidavit. I didn't see the domestic part anywhere in here.
I think they're all, it was two brothers and a sister. It looked that way. Let's see.
didn't see the brother. I saw the sister.
Well, the victim is Michael Lane, and then
Okay.
yeah, and the sister. So it was Gregory, Mike, Mitchell, and Lisa.
I see it.
All right, so I'm gonna set your bond in this case in amount of $1,000. Is gonna going to order that you have no contact with no contact with the victim, maintain a separate residence from the victim, one-time return with law enforcement.
Excuse me, Your Honor. Sir, I'm going to be representing myself in this case.
That's fine. We haven't got to that part. Let me finish what I got to do, and then we'll talk about your representation.
Okay.
One-time return with law enforcement, needs to retrieve any personal items he has at the location. Hold on a second. May not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You're not allowed to possess any drugs or alcohol without a valid prescription. All right, Mr. Lane, if you want to represent yourself, you have the constitutional right to do that at any point during the case. I don't have time to really at this point because I had around 30 other people to talk to this morning.
Right.
To have a Ferretta hearing with you. If your case is filed, you can talk to Judge Wayne Wooten about that, to tell him that you want to represent yourself. He'll do what they call a Ferretta inquiry to make sure you're competent to represent yourself in this criminal case. But that's not something someone's going to do today, but I'm not going to appoint a public defender unless you want me to. So if that's what you're telling me. No public defender.
Your Honor,
I won't do that.
I'm visually impaired, for one thing. And number two, I have my paralegal's degree. But the case, okay, I won't talk about the facts of the case, but I would like to get out ROR for medical reasons.
Okay.
I was under the care of my personal physician at the community health center, and I'm not a threat to the community or my family.
Okay.
I feel like, it's unconstitutional, for me to have a no contact order because it denies me, access to my, to confer with my accuser. Number one thing, I feel like domestic violence statute is unconstitutional.
That's something we can take care of. If you decide to represent yourself, all communications, depositions, everything will be in presence of the open court. All the things will happen. Those are all securities that we have in place for people that want to represent themselves and are charged with other crimes involving victims.
Right.
Additionally, Florida Statute 907.041 doesn't allow me to release you on non-monetary release. So I set your bond reasonably low for the charge of aggravated assault.
Yes, sir, but I don't want to get into the facts of the case. But actually, Lisa Lane called the police in order to.
I don't know. That's what I'm saying. Those are all things that can be factual. That's not. I'm not the judge for that. I'm the judge of release conditions, bonds, and things like that.
Right.
Facts and all those kind of things are to be held by the things to be covered by Judge Wayne Wooten, and not myself. He's a division judge in this case. All right.
I see.
All right. You have a great day, sir.
So ROR is out of the question.
Yes, sir.
Right here. No. Can I get a restraining order against a preliminary injunction against them tampering with any of my property because they violated the stand your ground law?
Once again, not the judge for that. That's something you got to take up with the division, like the injunction judges, which is the division of our courthouse. So.
I think I will go ahead and get that public defender then since
All right.
I'm not the acting judge
I will appoint the public defender to represent you then.
on a tentative basis.
Okay.
All right. Have a great day, Mr. Lane.
All right, do I need to sign that?
Nope.
Solve everybody's problems. Good morning, sir. Can you tell me your name?
Derek Scott Lang.
Mr. Lang, you're here in cases 2021 MM 711AW on charges of resisting officer without violence. Also here in case 2021 CF 13739AO on charge of assault, domestic violence, and burglary of a dwelling. Also here in case 2021 MM 710AW on charge of violation of a pretrial release condition in a domestic violence case. They reviewed the charging affidavits in all your cases, did find probable cause for your arrest as to all those charges. In 2021 MM 711AW, I want to set your bond in that case amount of $100. In 2021 CF 13789AO, in the first count, I'm going to set your bond amount of $500. In 2020, in count 2, I'm going to set your bond amount of $5,000 in count 2. And the condition is going to be the same in the felony case and the last misdemeanor case. So in 2021 MM 710AW, the violation of pretrial release condition of domestic violence case is going to set your bond in that matter amount of $10,000. Conditions of 2021 CF 13789 and 2021 MM 710AW, no contact with the victim. No return to the scene of the location. May not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. Want to appoint a public defender to represent you in all your new cases. You're out on bond in case 2021 MM 708AW, where Judge Bigney ordered you to have no contact with the victim. Apparently we didn't let that sink in. So in the court found a probable cause to commit new law offenses while you were out on bond and violated release conditions in that case. Of course, going to set your bond at no bond in that case. You have a great day, sir.
Your Honor, does he have an attorney? Because
I think he has a PD in.
I just want to make sure.
In the old case.
Okay.
Have a great day. No contact. Have a great day. All right. One, sir, can you tell me your name? Your name, please.
John Bias Cortez.
Sir, you're here in case 2021 MM 7450AO on a charge of battery domestic violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this case amount of $250. It's going to come with pretrial release supervision. You have no contact with the victim in this case. You're going to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you. Do you have any questions about the stipulations on your no contact order? All right. You have a great day, sir. One, sir, can you tell me your name?
Michael Balcom.
Mr. Ball, you're here in case 2021 MM 7448AO on charge of battery dating violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. I'm going to set your bond in this case amount of $500. It's going to come with pretrial release supervision. Say, was this previous case with the same victim?
It didn't occur in Orange County, Your Honor. I couldn't find it.
All right, no contact with the victim. Maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you. Do you have any questions about the stipulations on your no contact order, sir?
No, sir.
All right, you have a great day.
As soon as it, nothing to look any further. So let me go look.
All right, good morning, sir. Can you tell me your name?
William Campos.
Mr. Campos, you're here in case 2021 MM 7451AO on violation of domestic violence injunction. They review warrant affidavit. Let me
I
see.
couldn't see the actual facts of the violation
Let me see.
in the system.
All right. The warrant says October 17th. Do we have the affidavit somewhere? Back there in the back? No, it's not in there. No, I'm saying, when he scanned it in this morning, did they just forget or? All right, do you want to recall him this afternoon and see if we can dig up this warrant affidavit? I mean, there's a probable cause because there was a
Yeah,
warrant
there's
here.
probable cause. I just don't know the facts. I'm okay with
Other
it.
than on October 17th of this year, it says that you violated the injunction in some way.
Am I allowed to? Do you want me to speak on it or?
No, I don't. Because everything you tell me can be used against you. All right, sir, Mr. Campos is going to set your bond in this case in the amount of $5,000, condition that you had no contact with the victim in this case, and you abide by the injunction in 2021 DR 9910 AO. You had no weapons, you possess no weapons or firearms. The weapons or firearms you have need to be determined by law enforcement within 24 hours of your release. Now, Mr. Campos, two things. All right, you have a copy of your injunction? You know what the injunction, that's no contact order. So that's, we'll talk about that in a second.
Okay. Do I have a copy of that?
Yeah, do you understand the stipulations in your injunction?
I 100% understand.
All right, you understand the stipulations in no contact order, very similar.
Yeah.
All right. Just stay out of trouble. Have a great day. I'm appointed public defender representative, correct? I'm appointed public defender representative, Mr. Campos, if I didn't say it. All right. One, sir, can you tell me your name?
Ralph Davila?
You said Davila? Yes. All right, Mr. Davila, you're here in case 2021 MM 7439 AO on charge of battery domestic violence. They reviewed the charging affidavit in this case, did find probable cause for your arrest. And so these prior cases from a different victim, correct?
Yes, Your Honor, they are all, yes, they are different victims.
All right, Mr. Davila, we'll set your bond in this case amount of $1,500, condition of your bond. You have no contact with this victim. You maintain a separate residence from the victim. I need to give you one-time return with law enforcement to retrieve any personal items you have at the location. You may not possess any weapons or firearms. The weapons or firearms you have need to be determined by law enforcement within 24 hours of your release. I want to appoint the public defender to represent you. So, Mr. Davila, in these prior cases, did you have an opportunity to complete a batteries intervention course?
I'm taking one now.
All right. What week are you in right now?
I'm taking the Saturday class.
Yeah, so what week? So what week are you, like, how many weeks are you in? Because, like, it's about,
I just re-enrolled.
just re-enrolled?
That's correct.
All right. You need to
Matters intervention class.
focus, take it serious. If you work the program is very effective. All right? So the batteries intervention, but you got to complete the whole course. You can't stop in the middle. It doesn't help. You got to finish, you got to get all the way to the end, all right?
Is there any way I can ask for a no hostile contact order to return home?
No, I need the victim here for that. I need the victim here for that. So right now, with your history, I probably wouldn't do it. You got a lot of domestic violence history. So, but you need, if you're gonna try to better yourself, don't stop halfway, because that's what people do. They stop in like week 20, right when it starts getting hard, and you start having to really confront the things that are going on. You gotta get to the very end. All right. All right. Have a great day. All right, go on, sir. Can you tell me your name?
Tyler Fatigate.
You're here in case 2021 MM7432AO on charge of battery domestic violence. I did review the charging affidavit in your case, did find probable cause for your arrest. These prior domestic violence cases, same victim, different victims?
The victim is different, Your Honor. It's the same victim throughout, but it's different from this victim.
Okay. All right. All right, so we're gonna set your bond in this case amount of $1,000. Gonna cover pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you. And you as well may want to think about enrolling yourself in a domestic batteries intervention course to help you stop getting arrested for this charge.
Yes, sir.
All right, have a great day, sir.
Thank you.
Good morning, sir. Can you tell me your name?
Gabriel Hernandez.
Mr. Hernandez, you're here in case 2021 MM503AA on charges of 2 counts of battery. 1 second. Did review the charging affidavit in your case, did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
Yeah, Rachel Rios, Rios.
All right. And can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Can you tell me how you know Mr. Hernandez?
He was my boyfriend and we were living together.
Okay. And do you want to have contact with him while this case is pending?
No.
Okay. Did drugs and alcohol play a role in this incident?
No.
Say you got any questions for the witness?
No, Your Honor.
And Ms. George?
No, Your Honor.
All right. Hey, ma'am, were you the victim of this previous domestic battery case?
No, this is the first time I'm here.
All right, Mr. Hernandez, in both your counts, going to set your bond amount of $500 on each count. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. I want to have Ms. George talk to you if you have a question, because everything you ask me is on the record.
Are you planning on going back to your mom's house? Yes, I plan on, I just want to grab my stuff from his house, and including my car, and go back to my mother's house. Because he stated that they live separately, so I just wanted to make sure she wasn't going to be there.
You can't live with her, can't be within 500 feet of her residence. So if she's still getting her stuff out, you got to stay away. So you may want to not go back for a day or two just to make sure. All right? You have a great day. All right. Good morning, sir. Can you tell me your name?
Matías Ismael Iglesias.
Sir, you're here in case 2021 MM7440AO on charge of battery domestic violence. Did review the charging affidavit in your case, did find probable cause for your arrest. And this prior case, nobody know where it was from, same victim.
It's 2007. Victim's name is Norma Espinoza. It's not the same victim.
All right, sir, I'm going to set your bond in this case amount of $500. It's going to cover pretrial release supervision. You'll have no contact with the victim in this case. You're going to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you. Do you have any questions about the stipulations on your no contact order? Say again?
I'm okay.
Do you have any questions
No,
about?
I don't have any question. Thank you.
All right, you have a great day. Good morning, ma'am. Can you tell me your name?
Javino Miles.
Ma'am, we here in case 2021 MM 7433AO on charge of battery dating violence. Did review the charging affidavit in your case, did find probable cause for your arrest.
Yes. I'm sorry, can you repeat that one more time?
I reviewed your charging affidavit, found probable cause for your arrest.
Yeah.
Good morning, sir. Can you tell me your name and spell your last name? Cover your face. There you go.
Zachariah Ford, F-O-R-D.
All right. And can you raise your right hand and be sworn in? You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God.
Yes.
All right, you can put your hand down, sir. Can you tell me how you know Miss Miles?
She's my girlfriend.
And do you want to have contact with her while this case is pending?
Right, but I would not like to press charges.
Answer the questions. Do you want to have contact with her while this case is pending?
Yes.
Has there been previous instances of domestic violence between you all in the past?
No.
Did drugs or alcohol play a role in this particular instance?
No.
Okay. The decision whether to press charges lies with the state of Florida, not with the court. So, State, do you have any questions for the witness?
No, Your Honor.
And Ms. George?
No, Your Honor. However, I would ask for a no hostile contact order based on her criminal history and the testimony from the victim today, Your Honor.
And what do you say as to her out on bond case?
It looks like she was referred to pretrial diversion. I would ask that you take no action, being that it's a nonviolent offense, Your Honor.
Is she still on pretrial release even though is she in the PTD program?
She was referred September 2nd, Your Honor.
Looks like I had a note that she started a year ago in the program, so.
I'll double check, but I saw September 2nd as the referral.
So, Ms. Davis, I guess my question is, have you guys actually been supervising her on pretrial release?
He's still on.
Okay. All right. All right, Ms. Miles, going to set your bond in this case amount of $100, conditioning your bond that you have no hostile contact with the victim in this case. You are to not possess any weapons or firearms. Weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. Now, no hostile contact means this. You're allowed to have disagreements with people you're in a relationship with. That's a normal thing that happens in a marriage or any relationship with somebody else. However, those disagreements cannot turn violent. They cannot become threatening. There can be no abusive language used. Because no matter whether he calls law enforcement or somebody that sees you acting like this in public calls law enforcement, you're going to be arrested. You're going to spend a lot of time here with me at the Orange County Jail on no bond status. You understand that?
Yes, Your Honor.
I'm not going to take any action on your out on bond case. Seems that you probably shouldn't be done with that, but I'll let the state of Florida decide what they're going to do. I'm going to appoint the public defender to represent you. You have a great day, ma'am. Good morning, ma'am. Can you tell me your name? Man, you're here in case 2021 MM 7434AO on charge of battery domestic violence. I did review the charging affidavit in your case, did find probable cause for your arrest. All right, man, I'm going to set your bond in this case, amount of $1,000. It's going to cover pretrial release supervision. You're to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be determined with law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter. Do you have any questions about the stipulations or no contact order, ma'am?
No, it's just I don't live with her at all.
I can't say it?
I don't live with her at all.
Okay, so the question is, do you have any questions? The no contact order says you can't be within 500 feet of her residence, 500 feet of her in person, no contact whatsoever. So do you have any questions about those conditions?
No.
All right, you have a great day, ma'am. Good morning, sir. Can you tell me your name?
My name is Alan Wojciechowski.
What happened to Tucker? All right, this case 2021 MM7452 AW. Ms. Say it. AO, I'm sorry, AO. Ms. Tucker, going to appoint a public defender to represent her.
I'll waive the appearance, Your Honor.
All right, going to set her bond in this case, an amount of $1,000, condition her bond that she had no contact with the victim in this case, maintain a separate residence from this victim, give her one-time return with law enforcement to retrieve any personal items she has at a shared location, may not possess any weapons or firearms. Any weapons or firearms you have need to be she has needs to be determined with law enforcement within 24 hours of her release. Want to appoint already appointed the public defender to represent her. All right, sorry, sir. Tell me your name one more time.
What was that?
Tell me your name one more time.
Alan Wojciechowski.
Mr. Wojciechowski, you're here in case 2021 MM7443 AO on charge of battery domestic violence. They reviewed the charging affidavit, did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
My name is Larissa Wojciechowski.
All right. And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
If you could just spell your last name for the court reporter.
Wojciechowski.
All right. All right. And ma'am, can you tell me how you know Mr. Wojciechowski?
He's my husband.
And do you want to have contact with him while this case is pending?
Do I want to contact with him? No.
Yeah. Do you want to? All right. Did drugs or alcohol play a role in this incident?
No.
All right. Say, do you have any questions for the witness?
No, Your Honor.
And Ms. George?
No, Your Honor. Given the testimony, I would ask for a no hostile contact order.
You said no contact.
Oh, I'm sorry,
Yeah.
I misheard.
All right, Mr. Wojciechowski, you want to set your bond in this case, an amount of $500 is going to come with pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I give you a one-time return with law enforcement to retrieve any personal items you have at a shared residence. You may not possess any weapons or firearms. The weapons or firearms you have need to be determined with law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this matter. Do you have any questions about the stipulations in your no contact order? Do you have any questions about the stipulations in your no contact order?
No, just have a work vehicle in the driveway. Will I be able to?
Yeah, you got a one-time return with law enforcement. So get your work clothes, personal items, take your work truck, no TVs, sofas. Show up with a U-Haul, the police officer are gonna laugh at you and then tell you to go, like, they're gonna leave. So go get your stuff, pack it in a go bag, and You're on your way until a judge tells you you can have contact. All right? Have a great day. All right, good morning, ma'am. Can you tell me your name?
Wojciechowski.
Scott, since you're here in Polk County, case 2018 CF 4955, for a violation of probation warrant issued for your arrest out of Polk County, bonds and no bond. Bonds remain at no bond. I'm going to appoint the public defender to represent you till we get you over to Polk County. You have a great day, ma'am. Good morning, sir. Can you tell me your name?
Jared Wisdom.
Mr. Wisdom, you're here in case Highlands County case 2000 CF 457. Judge issued a warrant out of Highlands County, setting your bond at no bond. Your bonds can remain at no bond. I'm going to appoint a public defender to represent you till we can get you over to Highlands. You have a great day, sir. All right. Good morning, sir. Can you tell me your name?
Marks Hill.
Say it one more time.
Marks Hill.
Mr. Hill, you're here in case 2017 CF 9504AO for a violation of probation. Bond in that case is no bond. Your bonds can remain at no bond. You're a violent felony offender of special concern. You're not entitled to release or bail or bond on this case until your violation of probation is completed. I'm going to appoint the public defender to represent you. You have a great day, sir. Morning, sir. Can you tell me your name?
Tavares Hudson, sir.
So Hudson, you're here in case 2014 CF 10116AO for a violation of probation. Judge signed your warrant. In this case, set your bond at no bond. Bonds can remain at no bond. You're also a violent felony offender of special concern. You're not going to be entitled to release or bail or bond on this case until your violation of probation is completed. I'm going to appoint the public defender to represent you in this case.
Yes, sir.
You have a great day.
You too, sir.
Morning, sir. Can you tell me your name?
Good morning, sir. Eddie Jenkins.
So Jenkins, you're here in case 2019 CF 12694 on a charge of violation of probation. Judge signed your warrant, set your bond at no bond. Your bonds remain at no bond. Going to appoint the public defender to represent you. You have a great day, sir.
Is there a court date set for that?
What happened? Yeah. Jenkins?
Yeah. RR.
All right, not taking action on the Allen Bond case.
Yeah, it was the incident that caused the VOP.
Yeah. All right, have a great day, sir.
Is there a court date set?
Probably, what's today? Thursday? So probably Tuesday or Monday or Tuesday next week. You see Judge Lattimore. One sir, can you tell me your name?
John McSwain.
Mr. McSweeney, here in case 2017 CF 1321AO. Give me 1 second. On armed view violation of probation. Did find probable cause for your arrest based on a warrant in case 2021 CF 13217AO. What's that? Set your bond in that matter at no bond. Bonds can remain at no bond. Seem to be a violent felony offender, special concern, not entitled to release or bail or bond on that violation of probation until the violation of probation is completed. In 2021 CF 13217, this is a warrant for your arrest, finding probable cause for a violation of sex offender failure to register. Going to set your bond in that case amount of $3,500. Condition of your bond in that case that you have 48 hours from the time you're released from the Orange County Jail to report to the sheriff's office as a violent sexual predator or sexual offender. Going to appoint a public defender to represent you in both matters. You have a great day, sir. All right. Good morning, sir. Can you tell me your name?
Michael Wilson.
Mr. Wilson, you're here in case 2020 CF 7840 AO on a charge of violation of probation. Judge signed a warrant in this case, set your bond at no bond. You're going to say it? No, Mr. Wilson?
$7 bond.
No, you can't do that. No, let me see. Now, Mr. Wilson is a violent felony offender of special concern, 948.03, 948.06, I'm sorry. Not entitled to release or bail or bond on this violation of probation. Since violation of probation goes to hearing, I want to appoint a public defender to represent him in this matter. Let me tell Mr. Judge LeBlanc that I did that. All right, have a good day, sir. Yeah, no bond. All right, does anyone have anything else before we go into recess?
I had a case, Lutner of.
Good morning, sir. Can you tell me your name?
Ariel Barreiro. Ariel Barreiro.
Ariel Barreiro.
Sir, you're here in case 2021 CF 13796 AO on charge of possession of fentanyl. They reviewed the charging affidavit in your case, did find probable cause for your arrest. And stay your bond at $1,000, condition your bond that you have not possessed or consumed any drugs or alcohol without a valid prescription. I want to appoint a public defender to represent you. You have a great day, sir. All right, I think we'll do our arraignments and then we'll. All right, I think that was my only case.
Thank you, Your Honor.
All right, thank you. Have a great morning.
You too.
All right. Good morning, sir. Can you tell me your name?
Angel.
All right, I thought we were doing our arraignments. We're doing the move ups first? Which are we doing first? Move. All right. All right. You want to tell me your name one more time?
Angel Canales.
Mr. Canales, you're here in case 2021 MM 7449 AO on charge of resisting officer without violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Say, was there an offer to resolve this case this morning?
Yes, Your Honor, it's an adjudication of guilt, credit time served, no return to 1002 West Carter Street.
Mr. Canales, did you want to accept that offer from the state of Florida?
May I hear it again?
It's an adjudication of guilt, credit for the time that you spent, which I believe is 2 days in the Orange County Jail. This court cost of prosecution at $273.
He understands, Your Honor. He wants to accept it.
All right, sir, can you raise your right hand and be sworn in? You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
I can put your hand down. Sir, you're here on that charge of resisting officer without violence. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes.
You want to enter a plea of guilty or no contest to resolve this case with this morning?
No contest.
Do you understand by entering a plea of no contest, you're going to waive all the rights on the plea form, like the right to have a trial, challenge the state's evidence, call witnesses on your behalf?
Yes.
Are you under the influence of any drugs, alcohol, medication?
No. No right now.
Have you now or in the past been diagnosed with a mental health illness?
Yes.
What was that mental health illness?
Bipolar.
Are you taking any medications for your bipolar disorder?
No.
Are you suffering from the symptoms of your bipolar disorder right now?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Oh, okay.
If you understand, if you're not a United States citizen, you can be deported from this country based on a criminal plea. Do you understand?
Yes, I understand.
I had the opportunity to review your charging affidavit. In this case, it did find a factual basis contained therein. You're going to accept your plea of no contest. I'm going to find your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge, give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Welcome to an Econo meeting. You are entering the meeting now.
Good morning, sir. Can you tell me your name?
Nicholas O'Neill.
Mr. O'Neill, you're here in case 2021 MM7438AO on charge of trespass and occupied structure, refusal to leave. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Say it was an offer resolved, oh, so you're on probation. So, sir, we're going to stay your bond in this case. Was it $250? Bond is $500 or $250? Say your bond amount of $500, conditioning the bond that you not return to the scene of the location, had no contact with any victims or witnesses from this case. Going to appoint the public defender to represent you in this matter. You have a great day. Can we get Mr. Acunis next?
So am I getting released?
No, sir.
Good afternoon, Your Honor. Carlos Pius on behalf of Mr. Acutis. You able to hear me, Judge?
I'm here to hear you. I'm here to hear you.
Okay, good. Thank you. And thank you for allowing me to appear.
Yeah, no problem.
Telephonically.
One other question, Ms. Davis, for Mr. O'Neill, is he already being held on this violation?
Yeah, they just served it.
Okay. All right. I won't take any action on it. Jimmy Acunis? Say, are you proceeding on these prosecutions nowadays, or?
No, Your Honor. I was going to announce a no bill.
Let's get him in here. Okay. Good morning, sir. Can you tell me your name?
Jimmy Axius.
So you're here in case 2021 MM7441AO on charge of possession of cannabis. Counsel, can you put your name on the record?
Pius, Your Honor.
All right. And state, are you making an announcement as to this case right now?
This time the state announces a no bill.
Mr. Acunis, the state of Florida is announcing no information in your case. Going to release you your own reconnaissance as to this charge. I'm not going to take any action on your out on bond case 2021 CF 4064AO.
Well, Judge, I was hoping you would, because is there no bond on that case? Is that what you're indicating?
No, I said I'm not taking any action on that case.
Oh, so okay, so he'd be free to go then.
Yeah, he's free to go. He's just got to stay out of trouble.
Okay, thank you so much, Your Honor. Have a wonderful day. Thanks
All right.
again for allowing me to appear.
No problem.
Thank
Have
you.
a great day.
Bye-bye. Thanks. Bye-bye. Thank you too. Bye-bye.
Good morning, sir. Can you tell me your name?
My name is Eric Franklin.
Mr. Franklin, you're here in case 2021 CF 13800 AO on 2 charges, neglect of a child and contribute to delinquency of a minor. They reviewed a charging affidavit in this case.
It's
Not state that's the count 2.
Your Honor.
Let me relook at this. Yeah, find probable cause is count 1. Not sure about count 2 though. It requires, I mean, it's in need of services, but not of, not because he's going to become delinquent, or because he's going to become dependent.
Your Honor, would you mind giving me 24 hours just to do some more research?
Yeah, no problem. The last part of the statute, the only contributing delinquency to minor is, it talks about when a person making the child dependent on the services from like the department, but that's usually referring to, is you talk about the person becoming delinquent because they committed some kind of crime or something like that.
Okay.
This is a situation where the child's going to become dependent on, sort of like, as a dependent of the state, not a delinquent.
Okay.
So I'll give you the 24 hours. In count 1, I'm going to set your bond amount of $5,000, sir. In count 2, set your bond amount of $100. I'm going to get a state 24 hours to determine probable cause for count 2. Conditions of your bond in this case are no contact with the victim in this case, no unsupervised contact with a child under the age of 18 years old. May not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. So if you're not able to bond out, I'll see you tomorrow as it relates to count 2, Mr. Franklin. All right, have a great day.
I got you. Keep it up. You got it?
Good morning, sir. Can you tell me your name?
Ronnie Thomas.
Mr. Thomas, you're here in 2 matters. The first one being 2021 MO 1198 AO on charge of disorderly conduct. They reviewed the charging affidavit, did find probable cause for your arrest as to that charge. And you also arrested in 2021 CF 13794 AO on charge of carrying a concealed weapon by a convicted felon. The state, only issue I have with this one, he's said to be in possession of a chemical agent, but doesn't tell me how much of a chemical agent. So I don't know if it's a personal use pepper spray or big can of pepper spray or.
It's a personal use, Your Honor.
I don't.
I haven't done any
If it's
research.
2 ounces, if it's 2 ounces or less, then it's like the little small things you can buy at
Yes.
Academy or anything like that, or, but I've also had big ones, which would be considered a chemical agent at that point. This on the definitions in chapter 790.
Where's the PD?
Your Honor, I can ask the officer
All right.
for the size of it.
All right. Did you want 24 hours or you?
Yes, I'm here tomorrow. You're here tomorrow,
All right.
so.
All right, Mr. Thompson, did you want to resolve? Okay, so as to your felony case, sir, I want to stay your bond at $1,000. I'll get a say 24 hours to see if there is probable cause for the charge you're facing in your felony case. If you want to resolve your ordinance case, the city's offering a withhold of adjudication of guilt and court costs, but it's up to you if you want to resolve that today. 1,000. I'll set it 1,000. You're raising your eyebrows at me.
He'll resolve the city case, Your Honor.
All right. All right, Mr. Thompson, you can raise your right hand and be sworn in. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, you can put your hand down, sir. So you're here in the charge for disorderly conduct in 2021 MO 1198 AO. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case today?
Open the plea of guilty, sir.
Do you understand about entering a plea of guilty that you're going to waive? I'm sorry. Do you have a plea form?
You can't see.
Okay. All right. So do you understand that by entering a plea of guilty in this case that you're going to waive your right to have a trial in this matter?
Yes, sir.
Do you understand that trial, the state had to prove your guilt beyond a reasonable doubt?
Yes, sir.
Or the city had to prove your guilt beyond a reasonable doubt. You also had you have all had opportunity to challenge the city's witnesses, the city's evidence in that case. You understand? You understand you get a chance to call witnesses on your behalf.
Yes, sir.
If a witness does not want to appear for court, the court can use a subpoena power to make that witness appear. Do you understand?
Yes, sir.
You understand you're waiving your right to remain silent? That's a discharge. I can't hear you.
Yes, yes.
All right. You understand you're waiving your right to appeal any errors in this case, except the court's jurisdiction over you and the sentence I'm going to impose.
Yes, sir.
Are you under the influence of any drugs, alcohol, medication?
Yes, sir.
Have you now or in the past been diagnosed with a mental health illness? Has anybody forced, threatened, or coerced you to enter this plea?
Yes, sir.
Do you understand by entering this plea, if you're not a United States citizen, could subject you to deportation?
Yes, sir.
So I did have an opportunity to review a charging affidavit in this case, so I did find a factual basis contained therein. I'm going to accept your plea of guilty in this matter, finds your plea is freely and voluntarily entered. I'm going to withhold adjudication of guilt. I'm going to give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. Court costs in that case are $223. I'm going to give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. All right, so as your felony case, your bond's $1,000. If you're not able to bond out, I'll see you tomorrow. See if the state can raise some probable cause evidence in that case. All right, have a great day, sir. All right, Good afternoon, sir. Can you tell me your name?
White, still a white.
Mr. White, you're here in case 2021 CF 13777 AO on charge of robbery armed with a weapon. Reviewed the charging affidavit, did find probable cause for your arrest as to this particular robbery. I'm going to set your bond in this case, an amount of $15,000. Condition of your bond that you had no contact with any victims, witnesses, or co-defendants from that case. Not return to the scene of the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to return over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in that matter. You have a great day, sir. Bridges first. All right. Good afternoon, sir. Can you tell me your name?
Freddie Briggs Jr.
I can't hear you.
Freddie Briggs Jr.
All right, Mr. Briggs, you're here in case 2021 MM1581 AO on charge of battery domestic violence. Was this summons served? That's a first degree misdemeanor punishable up to 1 year in the county jail and a $1,000 fine. And state, you have evidence that I saw a summons was issued. Did you have it was served?
One moment, Your Honor. No, Your Honor. At this time, it does not appear that it has been served.
All right, so Mr. Bridges, I'm going to return this case to the state of Florida to perfect service against you. They should know where you are because I'm looking at you right now. All right, you have a great day.
Brandon Corbett is on behavior, Your Honor.
Next person I had was Christopher Smith. Brandon Corbett. No? I don't have any paperwork for that. You might know what case number it is?
The case number?
I don't have. No, I'm gonna look at it, I guess right here. All right, this is case 2021 CF 13749 AO. I guess the public defender was appointed, right? I guess not yesterday. All right, we're going to appoint a public defender to represent Mr. Corbett. All right, he's here, was here yesterday. I guess he had to get reset for a charge of carjacking with a firearm. And state, I believe you were requesting yesterday be held in no bond.
Yes, Your Honor, it's a PBO.
I think it's a life offense. And Ms. George, are you making an argument as to state's request?
No, Your Honor, I believe they wanted him to be brought back, so he was going to be held in the bond.
All right. All right, this case, going to hold him at no bond. Condition of his bond, no contact with any victims, witnesses from this case. No return to the scene of the location, no weapons, no firearms. The weapons or firearms he has needs to be returned to law enforcement within 24 hours of his release. He's on bond in several cases. Are these all competency cases? I'm just kind of looking at little notes from the first appearance pay sheet. All right, well, no, so not sure. Okay, all right, so he's out on 2021 MM7138 AO, 2017 CF 9610 AO, 2019 CF 2160 AO, and 2020 CF 14820. All right. In all the cases, what about the new case?
The new case, no. The other three
Alright.
cases, the older cases, yes.
All right, I'm not gonna take any action as to the felony cases. As to the new case, I'm gonna revoke his bond, I'm gonna set a bond amount of $10,000, no contact with the victim, no weapons, no firearms. The weapons and firearms he has need to be returned to law enforcement within 24 hours of his release.
I'm sorry, Your Honor, so which one are you taking no action and which one are you
The
revoking?
felony cases, so no action, 2017 CF 9610, 2019 CF 2160, 2020 CF 14820. Not taking any action in those cases because he's actually been deemed incompetent and based on the case law provided by Ms. George earlier this year. I'm not going to take any action on those cases, but as the case he hasn't been found incompetent, I did take action by giving him a bond, $10,000, no contact with the victim, no weapons, no firearms.
Thank you.
Where are we now? Good morning, sir. Can you tell me your name?
Christopher Smith.
Mr. Smith, you're here in case 2017 CF 332 AO on charge of driving license suspended. That's a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Ms. George seems to be represented by the public defender in this case. Did you have a plea you want to enter on his behalf?
Not guilty, Your Honor.
All right. Mr. Smith, I'm going to accept your plea for not guilty. Going to set you for pretrial in Division 82.
This trial will be November 15th at 10:30 in courtroom 10B.
Have a great day, sir. Yes. All right, that's a public defender client, 2021 MM427 AA. All right, we'll 7 for Division 82.
November 15th at 10:30 in courtroom 10B.
All right. Good morning, sir. Can you tell me your name?
Bertram Evans.
Mr. Evans, you're here in case 2021 MM7427 AO on charge of trespass on property after warning. That's a first-degree misdemeanor. Sorry, did find probable cause for your arrest. State, is your offer to resolve this case?
Yes, Your Honor. Adjudication of guilt, credit time served, no return to the Lynx bus station without a valid ticket.
All right. Mr. Evans, did you want to take the offer from the state of Florida?
What was that?
There's an adjudication of guilt, credit for the time you spent in Orange County Jail, this court costs and cost of prosecution.
Yeah.
Can you raise your right hand if sworn in? Do you solemnly swear to affirm that the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You put your hand down, sir. Sir, the charge of trespass on property after warning is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that? Okay, yes or no?
Yeah.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form that's in front of you right now? You got to say yes or no.
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yeah.
If you're not a United States citizen, you can be deported from this country based on this plea. Do you understand that?
Yeah.
Yep. Yes or no?
Yeah.
I did have opportunity to review the charging affidavit in this case. I did find a factual basis contained therein. Going to accept your plea of no contest. Finds your plea is freely and voluntarily entered. Going to adjudicate you guilty of the charge. You get credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. Court costs and cost of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Where's my public defender?
Afternoon, sir. Can you tell me your name?
Rafael Gaiafshik.
Sir, you're here in case 2021 MM252 AE and in 2021 MM253 AE. Both those charges are stalking. Did review the charging affidavit in both cases. Did find a factual basis, probable cause for your plea. Probable cause. Sorry, for your arrest in those two charges. Going to set bond in both cases an amount of $2,000. Condition of your bonds that you to have no contact with the victims in these cases. You are not possessing any weapons or firearms. The weapons or firearms you have need to be returned over to law enforcement within 24 hours of your release. I'll give 1 second. Yeah, please. Oh, I need it for both. Do you have any, I'm gonna get another order for you, but do you have any questions about the stipulations in your no contact order?
Do not, sir.
All right.
For your honor.
All right, has Sarasota placed a hold on him yet?
No, Your Honor.
All right. All right, because like quite sure Sarasota County is gonna be looking for you soon for violation of probation. I'm not taking any action right now, all right? If the state's asking me to.
Yes, Your Honor.
You are?
Yeah, if it's a non-view.
Yeah.
All right, sir, you're on probation in Sarasota County case 2020 CF 8175, and as well as 2020 CF 2565. Based on the state's request, the court's going to find an on-view violation of your probation in those cases. Corrections. And I'm going to set no bond in both cases. I'm going to appoint a public defender to represent you in all your cases. Once you sign this order, you have a great day, sir. Got to highlight it for you, I'm sorry. All right, good morning, sir. Can you tell me your name?
Max Weber Jermaine.
Mr. Jermaine, you're here in case 2021 MM 7435 AO on charge of petty theft. You're also here in case 2021 MM 7436 AO on charge of possession of cannabis. Your review, both charging affidavits did find probable cause for your arrest. So you're taking action as to the second case?
With regard to 21 MM 7436, state announces no information.
All right. So, sir, as to that case, I'm going to release you in your own recognizance as to that charge. As to your other case, your petty theft charge, I'm going to stay your bond amount of $250, condition your bond, no contact when your victims, witness, or co-defendants, no return to the scene of the location where the incident occurred. If you keep the same pattern, you're going to start picking up felony charges, and they're not going to send you to a program. They're going to send you to prison. All right? You have a great day, sir.
All right.
Good morning, sir. You can tell me your name. Mr. Rossi, here in case 2021 MM 7429 AO on charge of petty theft. Did review the charging affidavit in your case, did find probable cause for your arrest. We're going to stay your bond at $250, condition your bond, no, is that 250? 500? I'm sorry.
Your Honor, there is an offer from the state.
Okay.
An adjudication of guilt, credit time served, and no return to the public's located at 400 East Central Avenue.
All right. Mr. Rossi, do you want to take that offer from the state of Florida? All right. Do you understand that a conviction in that case can be used against you at a later date to enhance your sentencing up to a third-degree felony? Yes, I understand, sir. All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You put your hand down, sir. Sir, in this case, 2021 MM 7429 AO, the charge of petty theft is a second-degree misdemeanor. The maximum penalties are 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
I can't hear you.
No contest.
Do you understand by entering a plea of no contest, you're going to be waiving all the rights outlined on the plea form that's in front of you?
Yes, sir.
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you in this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
No, sir.
Do you understand if you're not a United States citizen, you can be deported from this country based on this plea?
Yes, sir.
I did have an opportunity to review your charging affidavit in this case, did find a factual basis contained therein. Going to accept your plea of no contest, finds your plea is freely and voluntarily entered. Going to adjudicate you guilty of the charge. You be credit for the 2 days, well, how many days? 2 days? They spent in the Orange County Jail with 2 days credit time served. Court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. And Ms. Rossi, you probably, you gotta go get, if you get out today, you gotta go register as soon as possible. All right, have a great day.
Your Honor, with regard to the 20 CF 12853, is it remaining at no bond?
No, he was already seen on that.
Yeah, he was seen on that.
Okay.
Yeah, it looked like I looked it up like he had already been seen, and that was a warrant arrest
Okay.
for that charge. Good afternoon, sir. Can you tell me your name?
That is Terrell.
Mr. Terrell, you're here in case 2021 MM7426AO on charge of trespass on property after warning. They reviewed the charging affidavit, did find a probable cause for your arrest. Say it was an offer to resolve Mr. Terrell's case.
Yes, Your Honor. Adjudication of guilt, credit time served, no return to 3024-36 North Powers Drive.
All right. Did you want to accept that offer from the state of Florida?
Yes, sir.
All right, sir, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down, sir. Sir, you're here in case 2021 MM7426AO on a charge of trespass on property after warning. That's a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand? Okay.
Yes, sir.
You want to enter a plea of guilty or no contest to resolve your case?
No contest.
You understand by entering a plea of no contest, you going to waive your right to have all the rights on the plea form in front of you?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yes, sir.
I did have an opportunity to review your charging affidavit. In this case, I did find a factual basis contained therein. Going to accept your plea of no contest. Finds your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge. Give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. Court costs and costs of prosecution in this case are $273. I'm going to give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Yes, sir.
Good afternoon, sir. Can you tell me your name?
Joey Antoine.
It's Antoine. You're here in case 2021 MM4761AO for a failure to appear. Judge in that case set your bond in amount of $500. Well, state was in an offer to resolve this case.
Adjudication of guilt, credit time served, no return to 482 West Oak Ridge.
It was showing, he was on probation.
Oh.
Oh, he's on, yes, he is on felony probation. All right, so I'm not going to accept that offer from Mr. Anton. We'll say your bond in the case of $500. We've already had a public defender appointed to represent you. You have a great day, sir. All right, this is 2021 MM1195AO. Ms. Cole, is she going to be available tomorrow?
Can we try for
This,
tomorrow?
yeah,
I didn't-
we'll reset it to tomorrow. Let's see if we can speak to her. Ferguson? 2021 MO1196AO, Ms. Ferguson.
We-
I refuse to leave her to come over, or? Ms. George, you want me to appoint you to speak with her so we can talk to her tomorrow?
Yeah, can we try tomorrow, Your Honor? There was an offer to resolve.
You want me to appoint you to represent her so you go talk to her, or you want to leave her unappointed for now?
Unappointed, Your Honor, because I'm not.
All right, we'll reset her for tomorrow, see if we can get that resolved as well.
I'm sorry, we reset Cole for tomorrow too?
Cole and Ferguson. All right, Taylor. All right. Afternoon, sir. Can you tell me your name?
Christopher Taylor.
Mr. Taylor, you're here in case 2021 MO1197AO on charge of disorderly conduct. The review, the charging affidavit did find a factual basis for that plea. Going to, probable cause for, Reviews your charging affidavit did find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication and guilt and court costs if you want to resolve this case today. Is that something that you want to do?
Your Honor, I don't. Your Honor, he doesn't have any criminal history. So I would ask for, I don't think he was able to be interviewed for pretrial release. I would ask for ROR pretrial release in this case, given he has no criminal history.
All right, sir, are you still saying there's a COE address?
Yes, the 2165, Twisted Pine.
2247?
Actually, now it's 2165.
All right, can we give him a change of address form? You got this? Ms. George, or corrections, can you grab this for her?
Thank you.
All right. Mr. Taylor, I'm going to release you on your own recognizance, condition your release, not return to the scene of the location where you were arrested. Going to appoint a public defender to represent you.
Thanks, Your Honor.
All right. Have a good day, sir. All right. Good afternoon, sir. Can you tell me your name?
Samuel J. Cruz.
Mr. Cruz, you're here in case 2011 CT 1827AE for failure to appear. Judge set your bond amount of $1,000. The state was there an offer to resolve Mr. Cruz's case?
I have it listed as a DUI, Your Honor. No.
Okay. All right. Bonds.
Strike home confinement.
Y'all check the home confinement since we don't have that any longer. I'll make a condition that you're not possessing or consuming drugs, alcohol while you're on release on this case. Don't operate a motor vehicle without a valid driver's license. And you already had a public defender? Sir, did you want me to appoint a public defender to represent you in this case, or you plan to hire your own attorney?
I need a public defender, please.
All right, going to appoint a public defender to represent Mr. Cruz. Have a great day, sir. Got things, sir? Can you tell me your name?
Henry Fields, sir.
Mr. Fields, you're here in case 2021 CF 6999 AO on charge of driver license suspended. CT, I'm sorry, 2021 CT 69999 AO on charge of driver license suspended. You reviewed the charging affidavit in this case, did find probable cause for your arrest. Say it was an offer to resolve Mr. Fields' case.
No, Your Honor.
All right, so Fields gonna set your bond amount of $500, conditioning your bond that you not operate a motor vehicle without a valid driver's license. Going to appoint the public defender to represent you in this matter. You have a great day, sir.
Yes, sir. Thank you.
Well, I should, yeah. Never mind. All right, got the sir. Can you tell me your name?
Ron Hudson.
Mr. Hudson, you're here in case 2021 CT 5973 AO on a failure to appear warrant. Judge in that case set your bond amount of $2,000. West State of Florida, you had an offer to resolve this case.
Adjudication of guilt and credit time served.
All right, Mr. Hudson, did you want to accept the offer from the State of Florida on adjudication of guilt, credit time served in this case?
I do.
You understand the conviction in this case can be used at a later date to enhance your sentencing up to a third-degree felony?
Yes, sir.
All right, can you raise your right hand as best you can? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Sir, this case is 2021 CT 5973, driver license suspended. That's a second-degree misdemeanor, it's punishable up to 60 days in the county jail and a $500 fine.
Yes, sir.
You understand that? All right. Do you want to enter a plea of guilty or no contest to resolve this case today? All right. Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea forms in front of you?
Yes, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
Yes, sir.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yes, sir.
Do you understand?
I'm not. Understand.
All right. Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
And that opportunity to review your court file in this case, it did find a factual basis contained therein. Going to accept your plea of no contest, find your plea is freely and voluntarily entered. Going to adjudicate you guilty of the charge, give you credit for the
3 days.
3 days? 3 days that you spend in Orange County Jail with 3 days credit time served. The court costs in this case, cost of prosecution of $306. I'll give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. I'm not taking any action out on bond case. You have a great day, sir. All right. And Afternoon, sir. Can you tell me your name?
Luxon Absolute.
Sir, you're here in case 2020 CF 9694AO on a failure to appear warrant. Judge in that case set your bond at no bond. Your bond is going to remain at no bond in this case. You already had the public defender representing you. You have a great day, sir.
Yes, ma'am.
One, sir, can you tell me your name?
Gene Bartholomew, sir.
Sir, you're here in case 2021 CF 13799AO on charge of delivery of controlled substance within 1,000 feet of a place of worship, selling delivery of methamphetamine, possession of methamphetamine, delivery of cocaine within 1,000 feet of a place of worship, and selling delivery of cocaine and possession of cocaine. They reviewed the charging affidavit in this case, did find probable cause for your arrest. Going to set bond in count 1, amount of $15,000, count 2, $150, count 3, $150, count 4, $15,000, count 5, $150, and count 6, $150. Condition of the bond, not return to the scene of the location. May not possess any drugs or alcohol without a valid prescription. May not have any may not associate yourself with any known drug dealers or drug users while you're out on release in this case. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
Yes, sir. Yes, sir.
Good afternoon, sir. Can you tell me your name?
Richard Hill.
Mr. Hill, you're here in case 2021 CF 13797AO on charge of grand theft motor vehicle. They reviewed the charging affidavit. I did find probable cause for your arrest. Going to release you on your own recognizance in this case. Condition of your release that you not have any contact with any victims or witnesses from this case. Want to appoint the public defender to represent you. You have a great day, sir.
Thank you, sir.
We got to this person?
You're online?
Welcome to an Econo meeting. You are entering the meeting now.
Okay. All right, good morning, sir. Can you tell me your name?
Seth Lewis.
Mr. Lewis, you're here in case 2021 CF 13765AL on charge of robbery with a firearm. They reviewed the charging affidavit, did find probable cause for your arrest. State we asking not to do that's to Mr. Lewis's bond.
Your Honor, robbery with a firearm is punishable by life. I ask you hold defendant no bond.
All right, and Mr. Lewis, I'm going to appoint the public defender to represent you in this case. Ms. George, you have a response to the state's request.
No, Your Honor, reserve right at the part.
All right, Mr. Lewis, as this charge, the court's going to hold you at no bond at this time. Condition of your bond that you had no contact with any victims, witnesses, or co-defendants. You not return to the scene, the location where this incident occurred. You may not possess any weapons or firearm. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And want to appoint the public defender to represent you in this matter. Sorry, appoint the public defender to represent you in this matter. You have a great day, sir. All right. Is it Morrowski? Questions? Can I get Mr. Morrowski next after this? Morrowski?
Your Honor, Whitney Bone on behalf of Ms. Morrowski.
Well, I want to get her up in a second. I'm going to keep rolling while we find her.
Okay, sorry.
All right, no problem. How are you doing?
Good, how you doing, Judge?
Doing well. I haven't seen you in like forever.
I know. It's been a while. I hope you're doing well.
All right. Good morning, sir. Good afternoon, sir. Can you tell me your name?
Michelangelo Mateo.
Sir, you're here in case 2021 CF 13394AL on charge of burglary of an occupied structure and grand theft. They reviewed the charging there's a warrant affidavit in your case. The judge found a probable cause for your arrest.
Your Honor, my client is currently unemployed, and the $5,000 bond is too much. We'll be asking if you would reduce count 1.
Well, Mr. Mateo, from the face sheet I'm looking at, has 22 prior felonies, 24 misdemeanors, 9 failures to appear, 38 unknown cases. as well as his most recent conviction was from March of this year. So I'm not sure if moving from the standard bond amount at this point is going to be something I'm willing to do. So I'm going to stay his bond amount of $5,000 as account one, or I'll set bond account two in the amount of $150. Condition of the bond is that you have no contact with any victims, witnesses, or in this case, not return to the scene of the offense. You're not possessing any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol without a valid prescription. I'm going to appoint the public defender to represent you in this case, sir. You have a great day. Morning, ma'am. Can you tell me your name?
Shannon Morrowski.
Mr. Morrowski, here in case 2021 CF 13802AO on charge of possession of methamphetamine and possession of drug paraphernalia. Counsel, you want to put your name on the record?
Whitney Bone on behalf of Ms. Morrowski.
All right. Morrowski, there was a warrant affidavit in your case. The judge found probable cause for your arrest as to those charges.
Judge, may I be heard?
Yeah, go ahead.
So Judge Blackman signed the warrant for this case, which, as the court's aware, this is with regard to an alleged third-degree felony, drug possession and a possession of paraphernalia misdemeanor, first-degree misdemeanor. Judge Blackman is the judge assigned to two pending cases before him in which Ms. Morrowski is the defendant and there has been charges alleged. I'd ask the court to consider a couple of things. First of all, Judge Blackman, in his position of already being the sitting magistrate in circuit court over her already pending cases, indicated on the warrant that he believed that PTR was appropriate in lieu of even having to post a monetary bond amount relative to the case before this court this morning, or this afternoon, excuse me, for initial appearances. So first of all, I'd ask the court to honor that. Ms. Morrowski, in the two pending cases in front of Judge Blackman, is already in mental health court. So based on that, and based on the fact that she is diagnosed with mental health diagnoses and is seeking treatment, based on the fact this is just an allegation at this point, I would ask the court to use its discretion and to not revoke her bond in the two existing cases in which she is in mental health court, and allow her to go back into continuing her treatment and allow me to fight these charges and enter a plea of not guilty on her behalf relative to the new offense.
All right, hold on, I'm looking at her other case. Looks like she has Vincent Sutro on one case.
He's representing her currently in the two pending cases that are before you as far as out of bond. In the instant case, I'll be representing her.
I just don't see a referral to mental health court in the court file.
In the two existing cases?
And I'm looking at 2020 CF 15294AO. I want to switch to our other case, but I don't see a.
If you look on the, I'm not sure, I know your system may be a little different, but if you look on the clerk's page, which is where I can see it, obviously, in both of those cases, there's an entry by the clerk on, I believe, excuse me.
All right, okay, the one case did, 11747 popped up as a specialty court.
Yes. And I may have misspoken. The other one may not be in that as well. I believed that it was.
Yeah, so she was referred last in July to mental health court. So she should be in front of Judge Lattimore for the problem-solving courts, not necessarily Judge Blackman. I don't think pretrial is going to let her be on pretrial. Quite sure I'm going to get a email directly after I would order that. So only I can offer her as far as pretrial services, I can release her on mental health pretrial release. She'll be probably held for the next day or two, screened by the doctors. And
Alternatively, I would ask that you just set a low bond then, Judge.
all right, seems that Ms. Morrowski has only one prior conviction. It's a lot of stuff from out of the state. All right, so Ms. Morrowski, I'm gonna set bond in count 1 amount of $500, count 2 an amount of $100, conditioning the bond that you not possess any drugs or alcohol without a valid prescription, you not associate yourself with any known drug dealers or drug users. Going to subject you to random drug testing in this case. Because if you are taking mental health or psychotropic medications, any other substance you introduce into your body is going to cause severe issues health-wise and mentally. You have Ms. Bowman representing you as to this case. Sorry, have a great day.
Thank you, Your Honor.
I'm not going to take any action to the other two cases. She's in front of Judge Lattimore, and Judge Lattimore and her team will address those cases as needed.
Good to see you, Your Honor. Thank you
Good to
so
see you.
much.
Well, I don't know if you can see the back of my head, probably, but good to see you.
Well, good to see that. Thanks a lot. I appreciate it.
All right, have a good day.
You too. Bye.
All right. All right. Catherine, sir, can you tell me your name?
Imran Mokhtar.
What happened? Is that Ronald? Hold on, say your name again.
Imran Mokhtar.
Oh, sorry. Okay, so there you go. So you're here in case 2021 CF13801AO on charge of robbery with a deadly weapon, attempted carjacking, battery on a law enforcement officer, resisting criminal mischief of $1,000 or more, tampering with a witness to hinder communication of law enforcement, battery, and resisting officer without violence. You reviewed the charging affidavit in your case, did find probable cause for your arrest. I'm going to set your bond in, well, actually, say what you asked and not do is to count 1.
Your Honor, I believe that he is entitled to a bond. It's only if it's a firearm. No?
He's not? Oh.
Robbery with a deadly weapon is with a deadly weapon. I believe it's a PBL if I remember correctly. With a firearm or a deadly weapon, robbery with a weapon is a F1.
Ah, I see the deadly weapon.
Check. It's 112. E12.
It is a PBO.
12.
It's a firearm or deadly weapon.
Yeah.
I apologize, Your Honor. Then,
12-1
based on it, the offense being punishable by life, I ask defendant be held no bond.
All right. All right, Mr. Sorry, I want to set, going to appoint a public defender to represent you in this case. Ms. George, you have a response to this request?
Your Honor, I would just ask that you use your discretion given his criminal history. I see the only thing he has in his history is the reckless driving. So I would ask you use your discretion to set a bond in this case.
Let me look at this again. All right, sir, I reviewed the charging affidavit again in this case, based on the information contained therein. And count one, I'm going to hold you at no bond. Count two, going to set your bond amount of $15,000. Count three, 150. Count four, 150. Count five, 150. Count six, 100. Count seven, 100. Condition of the bond: no contact with any victims, witnesses, or co-defendants. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I already appointed the public defender to represent you in this matter. You have a great day, sir. All right, good morning, ma'am. Sorry, good afternoon, ma'am. Can you tell me your name?
Angela Denise Moore.
Ms. Moore, you here in case 2020 CF 6629 AO on a charge of, for a failure to appear warrant. Judge, in that case, set your bond at no bond. The bond's going to remain at no bond in that case. You're also here in 2021 CF 13788 AO on charge of possession of cocaine and possession of drug paraphernalia. Did review the charging affidavit, did find a probable cause for your arrest as to that charge. Going to set your bond in that case, amount of $1,000 is count one, count two, $100. Condition of bond: no drugs, alcohol without valid prescription. You may not associate yourself with any known drug dealers or drug users. You may not, and you subject to random drug and alcohol testing in that case. State, did you make an offer as to this open trespass case?
She's on probation.
She's on probation, Your Honor.
Oh, I'm sorry. That's what it is.
I did.
All right. Oh, sorry. Yep, I saw that. All right, ma'am, I'm not going to take any offers as your case because you're already on probation, but you're out on bond in that case, so the court's going to revoke that bond, set a new bond at $0 as to that matter. I'm going to appoint a public defender to represent you in all your cases if you're not represented. Have a great day, ma'am. Good afternoon, sir. Can you tell me your name?
Pedro Rivera.
Mr. Rivera, you're here in case 2021 CF 13546 AO on a charge of grand theft motor vehicle. They reviewed the charging affidavit in your case, did find probable cause for your arrest. 1 second. Did you have an offer as to this open case?
Adjudication of guilt and credit. Oh, wait, no, this is Mr. Rivera.
Yep.
So withhold of adjudication and credit time served, Your Honor.
I'm sorry, yeah, Mr. Rivera, there's a warrant for your arrest. The judge found probable cause for your arrest. That's what I thought. All right. All right, Mr. Rivera, I'm going to set your bond in that case, the grand theft case, in the amount of $1,000, condition to bond. No contact with any victims, witnesses, or co-defendants. No return to the scene of the location where this incident occurred.
So,
Going to appoint a public defender to represent you in that case. Now, Mr. Rivera, did you want to resolve your case and your traffic cases open? You have an open case for no valid driver's license and no motor vehicle registration in case 2020 CT 5064 AO.
It's just no motor vehicle registration.
There's no motor vehicle registration? All right.
Yeah, oh, sorry, go ahead.
if it's possible to get resolved today, I would like to resolve it today.
All right. Can you raise your right hand and sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Sir, you're here in case 2020 CT 5064 AO on charge of no motor vehicle registration. The maximum penalties for that are 60 days in the county jail and a $500 fine. Do you understand?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contents.
Do you understand by entering a plea of no contest, you can waive all the rights outlined on the plea form that's in front of you?
Yes, sir.
All right. Do you have any questions about the plea form?
No.
All right.
I just wanted, because I know you guys hold me, I was supposed to get bond out yesterday, but I guess they hold me because of the driving without no registration.
Yeah.
So all I want to know is what's going to happen with this case.
Well, you told me you want to plea, so we're going to resolve the case right now.
Okay.
All right. But the question, do you have any questions about the plea form or any of the rights that you're giving up in this case?
No, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
Do you understand about entering this plea if you're not a United States citizen? It could subject you to deportation.
Yes, sir.
I had the opportunity to review your charging affidavit in your court file in this case. I did find a factual basis contained therein. Going to accept your plea of no contest. Find your plea is freely and voluntarily entered. Going to withhold adjudication of guilt. Going to give you credit for the 1 day that you spent in Orange County Jail with 1 day credit time served. Court costs and costs of prosecution in this case are $301. Going to give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment sentence in writing. All right. You may want to change the crew you're hanging out with, my friend. Mr. Rivera.
All right, the judges.
I'm sorry.
You may want to change the crew you're hanging out with because they're going to get you sent to prison.
Yes, sir.
Good afternoon, sir. Can you tell me your name?
Courtney Rozier, sir.
Mr. Rozier, you're here in case 2021 CF 126 AO on a charge of failure, sex offender, failure to register. Judge signed a warrant in that case, found probable cause for your arrest. Gonna set your bond in that case amount of $3,500. Condition of the bond, you have 48 hours from the time you're released from the Orange County Jail to report to the Sheriff's Office as a violent sexual predator or sexual offender. You also hear in case 2019 CF 66 AO and 2020 CF 12619 AO for failure to appear warrants. Judge in no case set your bond at no bond. The bonds will remain at no bond in those cases. Going to appoint a public defender to represent you in any case that you're not already represented. You have a great day, sir.
Yes.
All right. No, have a great day.
That's it.
Yep.
No bond. So I ain't gonna put out a bond now. Sit in here.
It's going to be me, they're going to be mine, or they're going to be Epperson's?
No, they're gonna be Epperson's.
Oh, what did you say? I thought you,
5B.
oh, you did say 5B. I'm sorry, my brain heard something else. I thought you said 4E. And my head said, yeah, and my head said, they're not mine, they're Epperson's, but, all right. Ellis Ortiz, good morning, please say your name. Thank you. Mr. Ortiz, you're here for arraignment. The charge is violation of probation on a domestic case. You are represented by the Public Defender's Office. How does the defense plead?
Let's enter denial this time, Your Honor.
All right, we're going to enter a denial, which is like saying not guilty, and we're going to set you for your next court date.
Yes, Your Honor.
Next court date?
DOP status hearing November the 18th at 2 p.m.
In courtroom?
4A.
Thank you. John Randolph? This, the one I just called? Yeah, I know, Sarah left me a note. Good morning, please say your name. Thank you. So, Mr. Randolph, you're here for arraignment. The state filed a charge against you in case number 20 CT 2853 of violation of probation. The underlying charge was a DUI. Are you still represented by Eben Self, or was that from before?
That was from before, Your Honor.
Okay, let me just look into the file then. Yeah, so we're gonna remove that because when a violation of probation happens, it's like starting the case again. It gets reopened, and then so if you have a lawyer, that lawyer needs to file new paperwork, or of course you can apply for the public defender also. So probation is saying that you left the residence without notifying probation, that you had a positive drug test, and that basically all your conditions are now due. They're not done, they're due. So that's where we're at. State, hold on one second. State, any offer? He's unrepresented at this point.
Your Honor, no offer at this time.
This is John Randolph.
Yes.
I was previously given an offer on the arraignment list that was a net revoke and terminate 30 days in court costs.
Yeah, no, I won't take that on the DUI. He's supposedly, according to probation, didn't do anything on a DUI where a lot of things are mandatory. So, and there's a positive drug test, no DUI school. That would not be an offer that the court would accept at this time. So, Mr. Randolph, do you want to enter a denial or an admission? So that's like saying guilty or not guilty.
Can I just say something first?
You can, but remember we're being recorded and anything you say the state can use against you.
Yes, ma'am, I know.
All right, go ahead.
I'm being held on this charge is actually ran concurrent with.
A felony probation,
yes.
right.
So I've already gotten an offer for felony probation.
Okay.
So my question is, how am I being charged with two separate violations when the charges are ran concurrent?
Because concurrent just means that they're happening at the same time. You have two different probations that you're supposed to be complying with. They just overlap in the time. Felony probation is one sentence. County probation is a separate sentence, but you're allowed to do them at the same time. Usually, if we don't say concurrent, they become consecutive. So you would have to finish one and then start the second one. We let you do them at the same time. So that's why you've got violations in both. And they're two separate cases and two separate charges. So there's nothing in the law that says you get double credit for committing two separate crimes. Yeah, and we can allow the punishment to happen together, but we're not obligated to. The law doesn't say you have the right to have it happen that way. So now, once the violation happened, they separated, they unconnected, and now they go back to being two different cases. All right? So, do you want to say guilty or not guilty to this? All right. Do you need a public defender?
I've been appointing Jeff Polk on the felony. So.
Okay. He has a PD on this case? Where's the application?
It's one number 49. You can barely see her little check mark.
It looks like the public defender was provisionally appointed by Judge Karsten at first appearance. I just need him to fill out the affidavit again, but we'll put the public defender on here. And then if you decide to get a private lawyer, that lawyer will have to do a substitution of counsel, okay? Thank you.
DOP status hearing November the 18th at 2 p.m. in Court Report A.
Thank you. Roxana White Porter Terran. Good morning. Please say your name.
Roxana White Porter.
Thank you.
You're welcome.
Ms. Porter, you're here for arraignment. The state filed a charge against you for, looks like violation of probation. Probation saying that you didn't report, you were supposed to finish your community service hours, they didn't see it, no proof of enrolling in the DUI school. And basically, that's what they wrote on here. And this is a new term of probation already. So we're here for arraignment, and you have the public defender. How does the defense plea?
Your Honor, we have granted an offer. It's a minimum term of 60 days. What we're last one is White Porter would like to enter into that plea.
Let me take a look. I would not at this time. I would accept 90 days revoke in term with credit for 60 and D6 until the DUI school and the victims class is done. What would you like to do, ma'am?
She'll do 90 days, Your Honor.
I'm sorry?
She'll do 90.
Okay. Ms. Porter, can you please raise your right hand? Do you swear to tell the truth, so help you God?
Yes, Your Honor.
Thank you. Please lower your hand. The public defender has an admission form there with your name on it. Did you sign that?
Yes, Your Honor.
Did you read it?
Yes, Your Honor.
Do you understand the rights that are in the form?
Yes, Your Honor.
Do you have any questions?
No, ma'am.
Do you need any more time to speak with your public defender?
No.
Are you acting under the influences of any medications, drugs, or alcohol?
No.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand that?
Yes, Your Honor.
And are you willing today to waive your rights and enter this plea so that you can resolve your case the way the state and your lawyer worked it out?
Yes, Your Honor.
Do you admit that you did not comply with your probation the way that you were supposed to?
Yes, Your Honor.
If you would have tried harder, do you believe you could have done it?
Yes, Your Honor.
So I find that you are alert, that you are intelligent, that you understand that your plea is freely and voluntarily entered, that I have a sufficient factual basis and I will accept it. It will be an adjudication of guilt, revoke and terminate probation, 90 days in the county jail with credit for 60. The DUI school and the victims class must be completed. The court will D6 the driving privilege until proof of those have been completed were filed with the clerk. And all other conditions not completed are waived except for the money. So it's $1,116 that's left over and $100 back cost of supervision. Those payments will be $25 a month starting in January. You have 30 days to appeal your sentence. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Good luck. You're welcome. All right, the next one I have, it says Shandon Paris, but it says David Chico.
Yes, Your Honor.
And
I believe he's not in custody.
right, and so I'm gonna skip that one because it's not until 9:30. The next one I have is Eduardo Rivera. Eduardo Rivera Torres. Good morning, please say your name. Thank you. This is set for a plea date, 20 MM 2769, represented by the public defender. Okay. State, I had previously asked that you notify the victim in this case so that he or she would have an opportunity to appear or to make a statement and to know what's going on. Was that done?
Your Honor, the state did attempt to contact the victim multiple times. However, we were unable to make contact.
Okay, thank you. Does the defense wish to proceed with the plea?
Yes, Your Honor.
All right, and do you have a plea form ready to go?
Yes, Your Honor.
All right, Mr. Rivera, please raise your right hand. Do you swear to tell the truth, so help you God? Let go of your junk.
Yes.
Let go of your private there. Move your hand. Thank you. All right. The public defender has a plea form there with your name on it. Did you sign that?
Yes.
Did you read it?
Yes.
Do you understand what's in the paperwork?
Yes.
Do you have any questions?
No.
Do you need any more time to speak with your lawyer?
No.
Do you feel like anybody forced you to make the decision that you're making?
No.
Are you acting under the influences of any kinds of medications, drugs, or alcohol?
No.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand that?
Yes.
And are you okay in English?
Yeah.
Oh, okay. I just want to make sure. Are you willing today to waive your rights and enter this plea so that you can finish your case the way the state worked it out for you with your lawyer?
Okay.
Do you want to take the offer and plea?
Yes.
Okay. How do you plead?
Guilty.
Wow, I'm looking at the pretrial status sheets in this case. They're all over the place as far as like different offers. So I'm trying to figure out what was the last offer. The last pretrial sheet says CDP. So defense, can you tell me what the offer is?
Yes, Your Honor. It's a withhold 12 months supervised probation, batter's intervention program, no hostile contact with the victim, and court costs.
Is this a DV or a simple bat?
Battery.
Because
It starts the battery, but it is with a domestic.
that's the domestic component, and that's why the state is asking for BIP?
Yes, Your Honor.
Okay. Mr. Yes?
My records show that it's no contact with victim.
She's saying that her records indicate no contact. Public defender had announced it was no hostile. So can we clarify?
Yes, Your Honor.
Is it no or no hostile?
Just one second, Your Honor.
All right.
Your Honor, it's no contact.
Okay. Mr. Rivera, how do you plea?
Guilty.
On November 13, 2020 in Osceola County, Florida, did you touch Michelle Rodriguez Medina without permission, without her consent?
Yes.
So I find that you are alert, that you are intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. Pursuant to negotiations, it'll be a withhold, credit for 45 days, followed by 320 days of supervised probation. Report to probation within 24 hours of your release. Probation starts as soon as you step out of the jail, so you have to stay out of trouble, you have to report, and you cannot have contact with Michelle Rodriguez until further order. You must enroll in the batterers program within the first 45 days, show proof to probation, and finish that program. You have to attend every week of the program. The court costs are $268. There's a $151 battery surcharge and a $100 public defender lien. We'll take that from the cash bond that you posted and we'll refund everything that's left over. You have 30 days to appeal this sentence. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. I know it's a withhold, but he needs to be printed. Thank you. Good luck.
Your Honor.
Yes.
Just for clarification on the record, the Assistant State Attorney, Joni Lillen, is assigned to this case, advised that she did make contact with the victim, and the victim advised that she did not wish to make a victim impact statement on this case. Thank you.
Trenton Watkins. #21 CT 753, #21 CT 754, #21 CT 756. Hey, Mr. Watkins, I don't have Mr. Kelly in here yet. I assume he's going to show up in person.
He's 7:45.
Right, yeah. So I'm a little early. I'm going to have you sit down. As soon as he gets in here, we'll call you back up.
Thank you.
You're welcome.
Your Honor, we have a lull in time, but there are food we can address if you want.
Yeah, I'm going to go back to do Mr. Diaz's case and call the interpreter. So Felix Diaz, 21 MM 1330.
Good morning, Your Honor. This is Alan Figueroa, certified special interpreter, already sworn.
Good morning. It's Judge Unsavich. I'm doing jail arraignments, so I don't have somebody here with a headset on, but they are hearing you from the jail.
No problem, Your Honor.
And it's case number 21 MM 1330, Felix Diaz del Canto, C-A-N-T-O, Canto. If you could just ask Mr. Diaz if he can hear you, please.
¿Me puede escuchar, señor Díaz? Yes, he can hear me, Your Honor.
Thank you. So good morning, sir. Please say your name for me.
Buenos días, señor. Dígame su nombre.
Félix Díaz del Canto.
Félix Díaz del Canto.
Mr. Diaz, you are here for an arraignment.
Señor Díaz, ¿se encuentra aquí en su vista incoatoria?
The state charged you with petty theft of $100 or more,
La fiscalía lo ha acusado de hurto de menor cuantía de $100 o más,
which is a charge punishable by up to a year in jail, a year of probation, and $1,000 in fines.
lo cual es sancionable con hasta un año de cárcel, con hasta un año de libertad vigilada y con hasta $1,000 de multa.
You are already represented by the public defender.
Ya está siendo representado por la Oficina del Defensor Público.
I'm going to ask your attorney, what is the plea?
Le voy a preguntar a su abogado o abogada cuál es el convenio.
Imputation of guilt, credit time served, no return in court cost, Your Honor.
Dictamen de culpabilidad, acreditarle tiempo cumplido, costas judiciales y prohibirle regresar al sitio.
Mr. Diaz, would you like to plead guilty or not guilty?
Señor Díaz, ¿desea declararse culpable o inocente?
Culpable.
Guilty.
Okay, can you please raise your right hand, sir?
Levanta la mano derecha.
Do you swear to tell the truth, so help you God?
¿Jura decir la verdad? ¿Lo jura ante Dios?
Sí.
Yes.
Thank you. Please lower your hand.
Gracias, baja la mano.
You have a form there that the public defender is holding up. Do you recognize that?
Usted tiene ahí un formulario que el defensor o la defensora pública le está mostrando. ¿Lo reconoce?
Sí, señor.
Yes, ma'am.
Did you read that paper?
¿Usted leyó ese documento?
Sí.
Yes.
Do you understand the rights that are in the form?
¿Entiende los derechos que constan en ese formulario?
Sí.
Yes.
Do you have any questions?
¿Alguna duda o pregunta?
No.
No.
Do you feel like anybody forced you to make this decision?
¿Acaso alguien lo ha obligado a tomar esta decisión?
No.
No.
Are you acting under the influences of any medications, drugs, or alcohol?
¿Se encuentra usted bajo los efectos de un tipo de medicamento, de drogas o de alcohol?
No.
No.
If you are not a U.S. citizen entering a plea is a reason to have you deported. Do you understand?
Aceptar un convenio declaratorio puede dejarlo sujeto a deportación si acaso no fuese ciudadano estadounidense. ¿Lo ha entendido?
Sí.
Yes.
Are you willing to waive your rights and enter this plea?
¿Está dispuesto usted a renunciar a sus derechos y aceptar este convenio?
Sí.
Yes.
On April 7th of this year in Osceola County, Florida, did you try to take merchandise out of Home Depot without paying for it?
El 7 de abril de este año, en el condado de Osceola de la Florida, ¿usted trató de llevarse mercancía de Home Depot sin pagar por ella?
Sí.
Yes.
And state, could you show the value of that property was greater than $100?
¿Y fiscalía pudiesen demostrar que el valor de dicha mercancía es mayor a $100?
Yes. Yes,
Sí.
Your Honor.
Sí, su señoría.
So, Mr. Diaz, I find that you are alert and intelligent,
Bien, señor Díaz, determino que usted ha tomado una decisión consciente,
that your plea is freely and voluntarily entered,
que ha aceptado el convenio libre y voluntariamente,
and that I have a sufficient factual basis and I will accept it.
y que existen fundamentos fácticos suficientes para sustentarlo.
It will be an adjudication of guilt,
Se emitirá un dictamen de culpabilidad,
credit for the time that you've served,
se le acreditará el tiempo cumplido,
no return to Home Depot,
se le prohíbe regresar al Home Depot,
$273 in court costs,
$273 de costas judiciales,
$100 public defender lien.
$100 de honorarios por el defensor público.
Report to the courthouse within 7 days of your release to the second floor to set up a payment plan.
Debe personarse al tribunal de Osceola dentro de un plazo de 7 días desde el momento en que quede en libertad al segundo piso para fijar un plan de pago.
You have 30 days to appeal. All appeals have to be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify.
Tiene 30 días para apelar. Si desea apelar, tiene que hacerlo por escrito, y si no puede costearse un abogado, se le designaría uno para ello.
Good luck.
Buena suerte.
All right. Ms. Nadal, who else did you indicate needed Spanish? Who's ready to go?
Mr. Arizona, however, he has a private and scheduled to 10:45.
Right.
And then, Mr. Cuevas has
Okay, is he there already?
Yes, Your Honor.
All right, and I'm sorry, what did you say his name is?
Ismael Cuevas Carrasco.
All right, let me find it, because I have to get through all Mr. Arzola's cases.
I staple all of this.
All right, I have for the interpreter, case number 21 MM 2625, Ismael Cuevas. Did the interpreter get that?
Yes, Your Honor, thank you.
Okay, great, thank you. So good morning, sir, please say your name.
Buenos días, señor, dígame su nombre. Ismael Cuevas Carrasco.
Thank you. All right, so we are set today for a defense motion. I'm sorry, go ahead.
Nos habíamos fijado la audiencia de hoy para un pedimento de parte de la defensa.
Defense, you may proceed.
Adelante, defensa.
Your Honor, Mr. Cuevas was found ICP in 19 CF 1155.
Okay, hold on. 19 CF 1155. Let me let the interpreter.
Su señoría, el señor Carrasco ha terminado con el ICP en el caso 19 CF 1155.
That was on December 18th, 2020.
Eso fue el 18 de diciembre del 2020.
We're asking the court to follow the findings of the felony court and find ICP due to intellectual disability in this case as well.
Quisiéramos pedir que el juzgado se base en la decisión del caso de delito mayor y que lo halle en determinación de ICP para este caso también por cuestiones de insuficiencia intelectual.
We're also asking the court to release him pursuant to Rule 3.212D.
También quisiéramos pedir que se le otorgue la libertad bajo el estatuto 3.212D.
So to clarify for the record, this is a hearing today with regard to release, not with regard to the court making findings for purposes of the state's prosecution.
Entonces, para aclarar en actas, esto es un pedimento con respecto a concederle la libertad, no con respecto a tomar decisiones o determinaciones de parte del juzgado para el caso de la fiscalía.
I'm assuming at that point, I'm assuming at some point in the near future that's going to happen, but we're not there yet.
Voy a asumir que en algún momento en el futuro eso ocurrirá, pero no hemos llegado allí todavía.
I apologize, Your Honor. I believe they both motions, so I probably we were addressing both today. But this is of utmost importance.
Me disculpo, señoría, yo pensé que habían radicado ya ambos y pensé que íbamos a tratar ambos hoy en día, pero el tema de la libertad es la más importante.
What I am seeing in the file, and I will look again to make sure my notes are not wrong, is that the defense's motions were filed October 14th.
Lo que yo veo acá en el archivo, y voy a revisar nuevamente para asegurarme que esté lo correcto, es que el pedimento de la defensa se radicó el 14 de octubre.
I don't know that it was noticed for both.
No sé si se había emitido una notificación para ambos.
The notice of hearing is really not specific enough.
La notificación de comparecencia para la audiencia no especifica lo suficiente.
And it doesn't really put the court or the state on notice that it would be potentially an evidentiary hearing.
Y no lo notifican ni a la fiscalía ni al juzgado que posiblemente sea una audiencia probatoria.
Let me ask the state attorney if they have an objection to what you're asking for, and we can then proceed the way we need to.
Déjeme indagar si la fiscalía tiene alguna objeción a lo que está pidiendo y después podremos continuar.
Your Honor, state has no objection to motion for ICP. However, the state would ask for conditional release in this case as ordered in 19 CF 1155.
Su señoría, la fiscalía no tiene ninguna objeción a que se determine el ICP en este caso, pero quisiera pedir una libertad condicional tal y como se estableció en el 19 CF 1155.
Are you saying no objection to both prongs of what the defense is asking for, or just to the release prong?
Me está indicando que no tiene ninguna objeción a ninguna de las dos ramas de lo que está pidiendo la fiscalía, o solamente con respecto a la de la libertad.
No, not ninguno de los, both of them. Are you saying you don't object? Well, no, maybe I heard it wrong. I'm sorry, maybe I said it wrong. Let me say again. Are you responding to one motion or both motions that the defense filed?
Su respuesta está dirigida hacia un solo pedimento de lo que ha radicado la defensa, o hacia ambos pedimentos que se han radicado.
For clarification, Your Honor, the state does not object to the motion for ICP.
Which part?
To
release?
No,
or
to the finding of, to the prosecution. However, the state does object to the motion for ROR and ask for conditional release.
Got it.
Thank you, Your Honor.
Bien, señoría, la fiscalía no tiene ninguna objeción con respecto al pedimento. ¿A cuál de ellos? Al que consta con respecto al determinar el ICP, pero sí desea objetar con respecto a la libertad bajo palabra y desea que se emitan condiciones para la libertad.
Okay, and then I would also note that the original motion filed on September 17th to find the defendant incompetent didn't have any report or information attached to it.
Y quisiera hacer constar que el pedimento original que se radicó el 17 de septiembre para hallar al acusado incompetente no constaba con ninguna información ni con ningún tipo de informe.
And that did not yet have a copy of the felony finding.
Y no tenía junto todavía una copia de la determinación en el caso de delito.
There's an amended motion filed the same day.
Hay un pedimento modificado, radicado en la misma fecha,
that still has nothing attached to support the motion.
que aún tampoco tiene nada añadido o adjunto que pueda corroborar con el pedimento.
It looks like it was Public Defender Jeff Volker who originally filed these.
Parece que fue el defensor público Jeff Polk quien radicó estos pedimentos originalmente.
Then on October 12th, there was another filing from the public defender.
Y luego, el 12 de octubre, hubo otro pedimento de parte de la defensa,
which was Miss Nadal,
lo cual fue la señorita Nadal,
and all the documents that were needed were then attached.
y todos los documentos requeridos estaban en ese entonces añadidos.
And then 2 days later, the motion for release and the motion to continue the finding of incompetence.
Y 2 días después, el pedimento para la libertad y el pedimento para hallarlo incompetente.
So, at this time, based on the findings in 19 CF 1155,
así que en este momento, basado en las decisiones del 19 CF 1155,
and without having any information that competency has been restored since that finding was made, the interpreter cut out completely.
Are you able to hear me, Your Honor?
I can hear you now, but it sounds like the connection is fading.
Oh, I apologize. Let me see what I can do here. Let me know if it happens again, Your Honor.
All right.
Y sin ningún tipo de información que nos lleve a pensar que la competencia sea restaurado desde ese entonces,
I am going to grant the motion and find that Mr. Cuevas is presently not competent to proceed in 21 MM 2625.
voy entonces a conceder el pedimento y tomar la determinación de que el señor Cuevas no se encuentra competente para proceder en el 21 MM 2625.
I am going to deny the motion for ROR.
Voy a rechazar el pedimento o a denegar el pedimento para libertad bajo palabra.
But I am going to release Mr. Cuevas on conditional release.
Pero sí se concederá la libertad condicional para el señor Cuevas.
And the conditions will be the same as the conditions in 19 CF 1155.
y las condiciones serán las mismas que se habían emitido para el 19 CF 1155.
And it's going to include a no return to the scene of this petty theft charge, no contact with the victim.
Lo que incluye también prohibirle regresar al lugar donde ocurrió este ilícito y le prohíbe el contacto con la víctima.
Your Honor, State would request a status hearing on this case.
Fiscalía, su señoría, la Fiscalía quisiera pedir que se fije una vista de seguimiento para este caso.
It looks like the felony court has a status date set for nothing, on demand.
Parece que el juzgado del delito tiene una vista de seguimiento fijada para... No hay fecha emitida todavía.
I'm going to have to give you a date sometime in January for now because that's as far as I have Judge Sanders' calendar.
Voy a tener que emitir una fecha en algún momento para enero porque esa es hasta la fecha en la que tengo el horario y el calendario del juez.
So that date will be forthcoming unless the clerk has it.
Esa fecha será anunciada más adelante a menos que la secretaria ya la tenga.
January 14th at 10:30 in 4A.
14 de enero a las 10:30 en la sala 4A.
Mr. Cuevas, you have to stay in touch with your lawyer.
Señor Cuevas, tiene que mantenerse en comunicación con su abogado.
You have to stay out of trouble.
No pueden cumplir con ninguna ley, meterse en ningún problema.
And you are not going to be allowed to return to Home Depot.
Y no se le permite regresar a Home Depot.
All right?
Bien.
Your Honor, just to clarify, is Mr. Corpus being found ICP as of today, or is it the day of the last complete motion?
Y su señoría, para aclarar, ¿la determinación del ICP es a partir de hoy o a partir de la fecha del último pedimento?
I find that it is appropriate to make the finding nunc pro tunc to October 12th.
Creo que sería apropiado tomar la decisión con respecto a esa única rama a partir del 12 de octubre.
And that was the first completed motion, not the last completed motion.
Y ese fue el primer pedimento que se radicó completo, no el último. Gracias, su señoría.
Thank you.
Gracias.
All right, and who else in Spanish that are yours? Anybody?
I believe that was it, because Mr. Corpus was
Okay.
the last one for this, but we have English.
Yeah, I have got a couple. Let me let the interpreter go. Thank you. Mr. Figueroa, okay?
Yes, Your Honor. I couldn't hear what the attorney said.
Oh, she said she doesn't have any others for the public defender who need an interpreter.
Okay, perfect. Thank you so much, Your Honor.
Thank you. Destiny Cruz, 21MM 2379. I had set hers to the side because she was going to fill out a plea form.
Your Honor, Mr. Cruz was sent back, however, she's no longer going to enter a plea. She'd like to enter not guilty.
All right, so we'll enter a not guilty, but she didn't ask for the public defender, so she's going to need to fill out an affidavit if she needs a PD.
It's already completed.
All right, so we'll give her a PD pretrial date and just wait for that affidavit to hit benchmark.
Pretrial December the 13th and 4A.
Thank you. All right, so I have State versus Shandon Paris, 20 CT 2297. Mr. Chico is present here in the courtroom. Hi, Mr. Chico.
Good morning, Judge. Mr. Paris just called my office a few minutes ago, said that he's running late.
Okay, I can wait if you can wait.
Yes, Judge.
All right, no worries, thank you. How about, we're still waiting on Mr. Kelly, he's not here yet. What about Carlos Maldonado, 20 MM 2831?
We can give you an update on Mr. Maldonado, but I believe that he intends to appear.
Oh, I see, never mind, we'll wait. I didn't notice that he wasn't in jail, I see that now. What about Mr. Luicius?
We can take that, Your Honor.
All right, so 20 CT 3283, 20 TR 47243, 47281, 47287, and he's present. Can we take out the note that he's in Orange County? Yes. All right, good morning, sir. Please say your name. Thank you. Counsel, what are we doing in this case?
Ms. Lucius is accepting an offer from the state, withhold $100 fine, BDI, and court costs. Mr. Lucius is being held in Orange, he's been sentenced in an unrelated case there. He'll be unable to complete those terms until he is released.
Understood. So he needs some time to get out.
Yes, Your Honor.
All right. Let me pull his driving record. All right, so that would resolve the no valid, which I'm fine with accepting based on what you all have told me. If he wants to resolve the careless by pleading guilty, we can take care of that one today, and I will dismiss the other two. So he'd plead to one infraction, and I would dismiss 2 infractions if he wishes to resolve those now as well. Would he like to do that?
Yes, Your Honor.
Okay, sir, can you please raise your right hand for me? Do you promise to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand. Sir, the public defender should have a plea form there with your name on it. Do you remember going over that paperwork with her?
Yes.
And did you sign it?
Yes.
Do you understand the rights that are in that form?
Yes.
Do you have any questions?
No.
Do you need any more time to speak with your lawyer?
No.
Do you feel like anybody forced you to make this choice?
No.
Are you acting under the influences of any medications, drugs, or alcohol?
No.
If you are not a U.S. citizen, entering a plea is a reason to have you deported. Do you understand?
Yes.
Are you willing today to waive your rights and enter these pleas?
Yes.
How do you plead?
Yes.
On November 24th, 2020 in Osceola County, Florida, were you driving without a valid license?
Yes.
And were you driving in a way that was potentially dangerous? In fact, you were in a crash.
Yes.
So I find that you are alert, that you are intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. In 20 CT 3283, it'll be a withhold, 268 in court costs, 4-hour basic driver improvement. 2020 TR 47243 will be an adjudication and $166. 2020 TR 47281 and 47287 will be dismissed. The class and the money will be due within 120 days of your release from jail. So whenever you get out of Orange County, whenever that's done and you're back home, you have 120 days from the day that you got out to do the class and to pay off the money, okay?
Yes.
You have 30 days to appeal. All appeals must be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. Please do not drive until you get a license, otherwise you could end up with new charges. Good luck, sir. Hey, Mr. Kelly, good morning. We have Trenton Watkins. He's over there already, ready to go. Oh, you need the prosecutor? All right. Gotcha. 21 CT 754, 21 CT 756. Mr. Watkins, while they're finishing up signing the form, can you raise your right hand, please? Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand and say your name.
Trenton Michael Watkins.
And appearance of counsel.
Nick Kelly for Mr. Watkins.
Thank you. So I don't know if you can see him. I'm never really sure what the camera angle is. Can you see Mr. Kelly?
No, ma'am.
Can you hear him?
Can you hear me?
Yes.
Okay, so that I just wanted to prove he's really here.
Okay.
And he can see you. And appearance of counsel from the state.
Lydia Boudin for the state.
Thank you.
Judge, he has 3 cases. They're going to drop the driving while license suspended, and we're going to plead to the DUI and then leaving the scene.
Gotcha. And let me just take a look. For some reason, Benchmark is not letting me pull this open the right way, so let me see if I can figure this out from here. So it's a second outside of 5? I see a DUI conviction in 07 in Orange County. More dual assistance speeding tickets than I care to count right now, but it's a second outside 5. Okay. So, Mr. Watkins, I know you can't see them clearly, but I have 2 plea forms here that Mr. Kelly gave me that have your name on them. Do you remember going over these papers with him?
Yes, Your Honor.
And did you read those papers?
Yes, Your Honor.
Did you sign them?
Yes, Your Honor.
Did you have as much time as you felt you needed to talk to Mr. Kelly about your options?
Yes, Your Honor.
And do you have any questions about your rights or about what we're doing here?
No, ma'am.
Do you need any more time to speak to Mr. Kelly?
No, ma'am.
Do you feel like anybody forced you to make the decision you made to take these offers?
No, ma'am.
Are you acting under the influence of any kinds of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen entering a plea is a reason to have you deported. Do you understand that?
Yes, ma'am.
Are you willing today to waive your rights and enter these pleas to resolve your cases?
Yes, Your Honor.
How do you plead?
Guilty.
On March 20th of 2021 in Osceola County, Florida, were you operating a motor vehicle under the influence of alcohol to the extent that your normal faculties were impaired?
Yes.
And did you leave the scene of an accident where there was property damage?
No.
Was that not one of the charges, Mr. Kelly?
Leaving the scene, abandoning the vehicle,
Oh, without,
leaving an ID.
without leaving any communication or form of identification?
Yes, ma'am.
So I find that you are alert, that you are intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. Mr. Watkins, everything I'm going to say next we will give to you in writing, but I have to say it out loud for the recording, and then probation will go over it all with you again, okay?
Yes, ma'am.
The court will take judicial notice of the driving record transcript and the name Trenton Michael Watkins, date of birth 7/27/83, certified by the clerk of court and kept in the normal course of the business of the state of Florida in maintaining driving records. I show a conviction for DUI under Mr. Watkins' name in 2007 in Osceola County, Florida. So the conviction for the DUI today becomes a second outside of 5. It'll be an adjudication of guilt, credit for 41 days time served, followed by 324 days of supervised probation. Probation starts as soon as you step out of the Osceola County Jail. You'll have 24 hours to report to the probation office. Do not drive, do not possess or consume any alcohol, and these conditions will apply until you have completed the DUI school and gotten the report back with regard to the recommendations for the treatment. You have a 6-month license revocation. That begins immediately. You have to enroll in DUI school level 2 within the first 60 days of starting your probation, show proof to probation, and follow through with all recommended treatment. You have a 10-day vehicle impound, which is due by the 180th day. It looks like state's asking for the victims class, so you'll have to do the victims class again. You have 180 days to do that. And when you do qualify for a license, you have to install an ignition interlock and keep that interlock on your car for a period of 1 year. When the DMV gives you your license back, that's when the interlock becomes effective. You're not allowed to drive any car that's not interlocked. So please make sure that you remember that. Obviously, until they give you a license, you're not supposed to drive at all. The parties have agreed on a $1,500 fine So with regard to a DUI, that ends up being $2,016. We'll talk about that, how to pay that in a minute. Let me get to the other case first, but I believe those are all the conditions of the DUI. And then with regard to the hit and run, it'll be an adjudication of guilt, credit time served, and court costs. The leaving the scene fee schedule is what will dictate those court costs, and that will be $316. So the fine and court costs for the one and the court costs for the other will go together into one account. Your payments for that will be $25 a month. I'm gonna let you start those in May, so that when you get out between now and May, you can focus your money and your energy on doing the other conditions. I would rather you pay to do your DUI school before you end up worrying about court costs.
Thank you.
State, you have an announcement?
Yes, Your Honor. In 2021 CT 756, the state announces the null pros.
And then, so the third case they dismissed.
Thank you.
You have 30 days to appeal this sentence. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Good luck, sir.
Thank you.
Yes, Mr. Kelly?
Yeah, he has some charges pending in Orange County, and I attempted to contact his public defender. Do you show a hold on him here?
I don't have anything,
The jail said I have a hold on County.
and I was just gonna ask corrections. They're the ones who would know the best. It's not showing in mine.
Yeah, it says I have a hold on Orange County.
That's fine. So because these three cases are now done, and you don't have, to my knowledge, anything else holding you in Osceola, you're gonna be releasable today to Orange. Whenever you get out of Orange, you have 24 hours to report to probation.
Yes, sir.
All right, thank you.
Thank you, Judge.
All right, good luck. Thanks, Mr. Kelly, nice to see you. Mr. Chico, you found Mr. Paris?
Yes,
All right, Shandon Paris, 20 CT 2297. Sir, you can come up and stand on the side of your lawyer. Hi, good morning. All right, let me click over. All right, so this is set for sentencing, and we gave Mr. Paris an opportunity to have a little bit more time to see what he wanted to try and work on with his license, because I believe an HTO was possible, and so I don't know if there's anything more the state or the defense wants the court to know with regard to what has happened.
Yes, Judge, I was gonna say I kind of botched this, but the kind of is wrong. I botched this, and I'm gonna tell you what I did wrong.
Okay.
It's more my fault than the court's, because I'm the attorney. When we sentenced him, when he filled out the plea sheets and I asked for the sentence to be not imposed for another month, what I meant is for the case, the 2297, which is an actual Willis, not to be imposed.
Not to be what?
Not to be, the sentence not be imposed, to be postponed. And instead what happened is that the other case number is the one that got postponed. And that's the one where he's gonna enter into probation, which he's ready to do. There's two case numbers.
What's the second one? I only have 2297, which is set for sentencing today.
2297, oh, is it?
And the plea agreement that was entered in this case is for probation.
Yes, the 229, to an amendment to an EVL and to probation.
Well, it was only going to be an amendment, my understanding, and this is up to the state, but my understanding was there would potentially be an amendment to a no valid if he came back and showed the state something. Either way, it wasn't going to be jail, but it was going to try, according to my notes, you all told me he was going to try to see if he can save himself from getting the 5-year revocation.
Okay, yeah, I did that wrong. What I meant for him is to enter in what my client's understanding, because this is what I told him, is for him to, the state was willing to amend it to NDVL no matter what. I asked for your discretion for him not to be sentenced on one of the cases, but I didn't want him to be sentenced on the actual DeWillis, on the actual driving while license suspended.
Well, this is the only open county case he has. The only two cases he has that show open or reopen are felonies. I don't know the status of those, but this is the only case he has with me. He had 2020 CT 2776, that's closed.
Right, that's on the day, the last time I saw you, Judge, he was sentenced on that.
Right.
And that's the one, what our intention was is that he would not be sentenced on that one because that one was a straight driving while license suspended.
All right, can I ask the public defenders to turn off the mics in there, please? That's okay. Well, Mr. Chico, I don't know how to rectify that mistake. That case is closed. That case was sentenced as a DeWillis with credit for time served. There's no legal basis for me to set aside that sentence at this point.
Oh, Judge,
okay.
As long as I could do the plea to the no valid driver's license, I still could make this work.
Well, he already pled to suspended in this case today. The sentencing has been set off. The state attorney's offer is what you all were working on. I had nothing to do with the offer.
No,
I was willing to give him a little bit more time
to
work on seeing if he could take advantage of that. If the state is going to tell me that they agreed that the court would impose a sentence that found him guilty of a lesser no valid, I'll consider what you're telling me. But he's already HTO'd. The DMV HTO'd him on September 14th.
Yes, Judge, because he pled guilty to a DeWillis.
Right.
And I just have, there's 3 civil DeWillis's. I've made 2 of them disappear for a person who was HTO. And the third one, the hearing officer just gave me the wrong order, so I had to resubmit it, and I'm just waiting for the hearing officer to sign it. So I'm one civil case away from withdrawing his HTO.
Okay.
And that's why.
State.
Your Honor, the state was under the impression that today we would be amending to the no valid, and.
Were you expecting to see proof of something?
No, I was not expecting. I mean, that would change the state's position if there was proof of something, but I was under the impression that we were going forward with the plea to the no valid.
So then what was the whole point of us setting it off at all? We could have just pled him I could have just sentenced him that day.
I think from my understanding, what's going on.
He didn't anticipate going forward on the last Willis.
Exactly. He meant to plead last time to the no valid, and then not to plead to the DeWillis.
But they were both DeWillis's at that time.
Exactly. But our negotiation was to amend one of them to the no valid. So I think that, if I'm understanding correctly, at the last court date to plead to the no valid and was hoping to have the license reinstated today.
Okay.
Yeah, this set me back because it put another DeWillis on the record.
Okay. So I understand then. Mr. Paris, is there anything that you'd like to say before the court sentences you? And it's supposed to be still probation, but just charged as a no valid?
Yes, Your Honor.
All right. Anything further from the state?
Nothing further, Your Honor.
Mr. Chico, then pursuant to negotiations in 20 CT 2297, the court will find Mr. Paris guilty of driving with not having a valid license in his possession while he was driving. It'll be an adjudication of guilt, 13 days in the county jail with credit for 13 days already served, followed by 167 days of supervised probation. Probation will begin today. There's a probation officer down the hallway, so once you get your paperwork from the deputy, go down to room 4E1, and that probation officer in there will get you signed in. Don't drive till you get your license back in your possession, and take a driving while licensed suspended class. You've got 120 days to do that. And you have 45 hours of community service that you have to serve at a rate of not less than 9 hours a month starting the first month. Your court costs are $273, and You have a $50 public defender application fee. Those payments will be $25 a month starting in May. That way you can be finished with this probation by the time that kicks in, so you could focus your money on doing the other things you need to do. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. So this one's a no valid.
Yes, Judge, and that's what I needed. And when I come with a license, not if, when we come with a license, would you be open to an early termination at that time?
I don't know. It depends. Yeah, he's going to have to file a motion for early term, and we'll consider it at that time.
Absolutely.
Thank
you for your patience. This got
no problem.
A little bit more complicated than normal, but
not a problem, Mr. Chico. Thank you.
The state kind of remember what we tried to do, and that's awesome.
Sounds good. Thank you. All right, so back to the public defenders. I believe the PDs said they had some other people. You need a minute? It's fine.
We are done with Jill, Your Honor. We just have the comp status for Mr. Maldonado at 10:15. I'm just going to make one for us to leave and we will get there in time.
Right, I understand. So if you want to stand by once he walks in, I'll let you know.
Yes, thank you.
Is there anybody from the afternoon that the jail wants me to try and take care of before they get transported?
I believe that...
Is anybody here yet? Do we know?
Most of the afternoon is from the jail is ED, so unless Jody's there, I don't think we'll do it. I don't think Jody's taking the morning off.
Oh, okay. All right, so that's fine then. So stand by till 10:15 and we'll see if your client shows up. Thank you. So we'll take a brief recess, 15 minutes. Okay, so we're back on the record. Mr. Arzola, if you want to come on up to the microphone, your attorney is here. I have to say these for the record, but there are many. 21 CT 1543, 21 CT 1545, 21 TR 21501, 21502, 21504, 21505, 21506, 21508, 21509, 21510, 21512, 21513. I said 20512, I meant 20512, 20513, 21565, 21567, 21568, 21569, 21571, 21572, 21573, 21574, 21615, 21617, 21618, 21620, 21621, 21623, 21625, and 21626. Appearance of counsel for the defense.
Yes, ma'am.
Say your name, please.
Yes, Ian Ivano here on behalf of Mr. Arzola.
Thank you. Mr. Arzola, please say your name.
Good, Wojciechowski.
Do you understand English?
Yes.
Okay, great. I know you can't see your lawyer, but he's here. Did you hear him?
Yes.
Okay. So, Mr. Beno, two of these cases are CT cases. What I show is that they were alleged to have occurred on June 5th. I looked up all the felony cases that he's in custody on. I didn't see any of those that said June 5th, but I did see many of his TR cases that I just announced connected to one or more of the felony charges that he's sitting in custody on. The felony judges won't take the TR cases. Even if they're related, they feel that it's county jurisdiction, I don't typically require anything to be done with them until after the felony cases are done, because I understand the implications of, for example, if he pleads to a careless driving that puts him behind the wheel of the vehicle, then that can be something that's used against him in a very serious felony charge. So I'm okay with continuing these if strategically you think that that's what's in your client's best interest.
The TR, you mean?
The TRs, for sure. We'll talk about the CTs separately in a minute, but I wanted to just let you know and let Mr. Arzola know, the felony judges don't want anything to do with the TRs, so they just keep them in county court. I'm not in any great hurry to finish the TR cases. I'm willing to let you wait to see how your CFs are going to play out, the ones that are related.
Well, if he pleads to the CT, that's still, it's a no contest plea, so I think, well, my whole thing, Judge, was if we can plead, the state's offer was plea to 1, the no registration, time served, and then drop the attached and tag not assigned, and then the TR cases, I was gonna ask the court to see if the court is willing to dismiss all of them or some of them.
27 tickets? No, there's no way.
Okay, how
I
many?
need to know, I don't know anything about the situation. I'm not gonna just throw them out just because he's also facing felonies, but I'm not requiring him to enter into a resolution today because I know how they're implicated in the felonies. The two, like I said, the 2 CTs don't appear to be related, so if he wants to resolve those today, I don't have a problem with that.
I think they're from the same, let me see, data.
It's June 5th. None of the felony cases allege June 5th.
But I think what happened is this was when they arrested him for a warrant, this is when all these TRs were happening and the CT for the warrant for the felony.
Okay, but the fact that on June 5th, he might have been operating an unregistered vehicle, June 5th is not alleged anywhere in the CF cases that I saw.
Right.
So if he says, yes, on June 5th I was driving an unregistered vehicle, it doesn't appear to affect any of the felony cases. They all have different dates. Whether or not they stopped, the basis for the stop was a warrant, I don't know. But I don't see the bleed over. Now, if you don't want to resolve the CTs today, you don't have to. I was just saying to you, my quick review doesn't look like they implicate him in any of the felonies.
With that same logic, how does the TR, what's the holdup in the court resolving the TR then? If the TR is not related to the felony, why do we have to wait for the felony to get resolved for the TR cases?
Well, if you would have looked at the TR, the first one that's there, 21 TR 21501, the date of offense is May 25th. So they're saying that he was driving on the sidewalk on May 25th, and specifically 21 CF 1601 are charges that arose on May 5th. So if he says, yes, I was in the car driving on the sidewalk on May 25th, does that put him behind the wheel for purposes of 21 CF 1601? Or does that at least put him anywhere that might implicate him in 21 CF 1601?
Well,
he has several tickets that allege May 25th, and then he's got
one on 9-2 too, failed to stop. One of them is.
Yeah, all of them are May 25th. Overtaking and passing a vehicle cutting in, passing in a no passing zone. I mean, if he's got a fleeing and eluding or that puts him behind the wheel.
But he also has a 9-2, failed to stop at stated light. So, Your Honor, I'd probably ask for a continuance, because I wasn't representing on TR. I need to look at all these TR cases and figure them out, because there's a 9-2 date. Oh, I'm sorry, there's one filed on 9-2, the rest are 527, so I don't know.
525 is what I show.
Well, the one I have is proof, where is it at? On page 9. 2021 TR 21502, failed to stop at stated red light, 9-2. And then there's a...
Mine doesn't say 9-2, mine says 525.
No, I was just going by what the docket said here, so maybe the docket is wrong.
Hold on, let me look that one up, 21502. you gotta look at the date that the ticket was issued, not the date that it was filed, and it says May 25th, 2021. I don't know where 9/2 is just a court date, an entry in benchmark of when the court date was set.
Okay.
9/2 does not appear to be anything related to when this charge allegedly happened. So it looks like they're all September 25th, which again is 21 CF 1601. And 1601 is charged as possession of fentanyl, possession of paraphernalia. I don't know if there's a suppressible issue with regard to the stop in those. I'm not saying there is, but what I'm saying is that obviously if he pleads to the driving and you challenge the stop, that could implicate him. I don't know. I was just trying to be fair and to look at the big picture, and even though these look like small potatoes compared to the felony charges, they could bleed through. So it's up to you if you want to continue everything or if you want to resolve the 2 CTs and just continue the TRs. That's fine with me.
Your Honor, I think, because he has different felonies, I only represent him on some, the PD represents him on the others, so I think it's better if I continue everything so I can talk to, figure everything out, just so that we're not doing anything.
I agree. That was my logic as well. I see that some of the felonies are set for various dates. The 21 CF 1601 is actually set for trial, pretrial and trial. Pretrial in front of Judge Young, October 27th, so next week, with a trial period anticipated starting November the 8th. Do you want a date in November or do you want a date in December?
November will be fine, Your Honor.
November's fine? Yes. For everything?
For everything, Your Honor.
Do you anticipate that he will be out of custody by the next like right after your next pretrial, or no?
I have a DOC offer on the felony cases, so I need we need to look at that felony cases.
Let's do November 18th. Will that work?
Is that for a plea or?
No, it's just for a status, and if he chooses to plea, he can, or we can do December 2nd.
Let me look at my calendar, Judge. 1 second. November 18th.
Or December 2nd.
I have a bunch of hearings on the 18th. The 2nd will probably be better, Your Honor.
All right, so December 2nd at, let me just find a time, and then you can do it the same as we're doing it now. You're welcome to be here, or you can go to the jail if you want to, and he'll appear via jail.
Yes, sir.
10, so 10 o'clock on the 2nd. Mr. Arzola, he'll come talk to you and explain all that to you. But you're not in custody on any of the cases that are in front of me, so this has nothing to do with your jail. That has to do with the felonies. So we're gonna put these off a little bit more and see what happens with your other cases, okay?
Thank you.
You're welcome. All right, thank you very much. Have a good day.
I may excuse.
You may.
Apologize for running late. I was doing a virtual hearing for Polk and
No worries.
in the elevator. I would have.
They told me, no problem.
It was a 10:15, but I got called late on that one.
I understand, not a problem at all.
All right,
Thank you. All right, we are in recess until the 1:30 docket begins. Thank you at the jail.